rise. The Justice of the Appellate Division, Supreme Court, First Department. He, all persons having business with the Appellate Division who are near, give your attendance, you shall be heard.
There's Lisbeth. Good afternoon. Thank you. Good afternoon, everyone. Welcome to the Appellate Division, First Department. This afternoon, we have some 5 hours of argument requested, so I ask that you keep that in mind as I call the record. Remember, with it, we have your briefs, we have the record, we're fully familiar with the facts of your case. So when you're asking for time, just ask for the time you absolutely need to make your most important points. Okay. People versus Naquan Leckie, submitted. Hopwin Lingerie versus Underboss Productions. I'll give you 5, 2, and 5. Melendez versus 1595 Broadway. And the other respondent? Oh, sorry, okay. Okay. 5 and 3, 5 and 5. Cruz versus Komatsu America Corp. Any respondent? No. Do you wish to submit?
If you give me 2 minutes, Your Honor, just to talk about one small point.
I think there's only one small point. Okay. Great Lakes versus American Steamship.
American Steamship 10 and 2, please.
Just a moment, please. Okay. You have to speak up and just let me know who you represent. I will give you 7 and 2, 5 and 2, and 7. Just remember, if we need to ask more questions, you will continue and ask our questions, so you'll get the time. People versus Luis Vargas. 5, 2, and 5. Lizard O's versus Baja Lounge.
For the account, represents 7 and 3.
Respond in 5 minutes, please, Your Honor.
I'll give you 4, 2, and 4. Balbuena versus 395 Hudson.
Appellant, respondent, MPI requests 4 and 3. Respondent, appellant, 395 Hudson, 4 and 1.
Four and 3, 4 and 1, 2 and 5 and 2. Thank you. People versus Tashawn Williams is submitted. Honeydew Investing versus J.P. Morgan Chase. Give you 7, 2, 7, 2, and 2. MLRN versus U.S. Bank. Okay, I'm going to give you the speech that one of our very special jurists used to give, which was, we have thousands, hundreds of thousands of great lawyers in New York, but we'll allow you to argue today. And how much time? 8, 4, 8, and 1. Thank you. People versus Aaron Carson.
5 and 2, Your Honor, please.
5, 2, and 5, thank you. Galicia versus Asrar is submitted, and 902 Associates versus Union Square is submitted. First case is Hopwin Lingerie versus Underboss Productions. Thank you. You may begin.
Good afternoon, Your Honors. May it please the Court, my name is Henry Gandhi. I represent the appellant, Israel Sasson. Language matters. Words used in contracts matter. When it comes to enforcement of a personal guarantee, just like any contract, its terms must be strictly interpreted. In this case, my client, Israel Sasson, executed a personal guarantee guaranteeing 21.21% of a note between plaintiff Hopwin Lingerie and co-defendant Underboss Productions. The note was for $800,000. It consisted of some trade debt and a loan. If the note was enforced on that very day, my client would owe 21.21% of that $800,000. It comes out to roughly $170,000. However, that note was amended. On December 2020, the original parties to the note, Hopwin Lingerie, Underboss Productions, along with the co-defendants, David Cohen and Joey Esses, executed an amendment. It was an agreement that amended the note. Throughout the agreement, the language is clear. It's the intent, it's the desire of the parties to amend the note. In fact, in Section 7 of that agreement, effect of this agreement amends the payment.
Counselor, did the agreement reduce the obligation of underboss?
I would argue yes, Your Honor.
Well, I know you're arguing yes, but did it, in fact?
Yes.
Words matter, right?
Yes.
How did it?
Well, if you supplant the payment schedule in the agreement into the note, it's an amendment after all, that's what it does. There's clearly language there that says this is David Cohen and Joey Esses' obligations. It's their obligations on their shoulders. If this is indeed an amendment, which it is, that's what happens. So if we have in a document that says $630,000 is the obligations of David Cohen and Joey Esses, my client never guaranteed the obligations of those two people. They guaranteed the obligations of Underboss.
Well, which is correct. So then, again, same question. Where in the settlement agreement, I know that you're making arguments that it was implicitly amended, where it was expressly amended, reducing Underboss's obligation.
I could hear the question.
Where in the settlement agreement was Underboss's obligation reduced?
Well, being that this is an amendment, I think that's the only logical conclusion you can come out from the document. If you, like I said, if you supplant that language into the note, there's no other way to look at it. It says over and over, these are the obligations of those two individuals. These are the obligations. If it's their obligations, it's not my client's obligation.
So, counsel, right? It says those are the obligations of the guarantors, right? Not Underboss. Underboss isn't the guarantor. It says here's what the guarantors will do. It says nothing about and concomitantly we're reducing Underboss's obligation.
Well,
it only says, correct me if I'm wrong, that the guarantors will pay this amount, correct?
Correct. It's the guarantee.
It did not in any language make the amount that Underboss owed any less. It just talked about how the guarantors were going to pay it, correct?
Well, I agree with you, Your Honor. That's exactly the point. The guarantors now under the note have to make those payments. It was silent as far as...
No, there's no release of Underboss. There was zero release of Underboss. It just said, so I don't immediately declare a default, here's what the guarantors will pay.
But also...
It didn't release even a penny of Underboss's obligations.
I don't think that the agreement says that they're both liable simultaneously for that $630,000. The effect of this agreement amends the payment schedule for the guarantors only. And yes, it does call them guarantors, but it's defined as those two individuals just because they are guarantors. But we can't escape the language that it says that they are amending the note. I see my time is up. Is it up?
It'll be up in 45 seconds.
I actually have a couple of things to say about that. It didn't just take the obligations of the $630,000 and give them an extended schedule, because under the way things were originally constructed, David Cohen and Joey Esses both owe different percentages of that $630,000. But this agreement made it 50-50. I mean, that's how they even applied the payments. If you take that $630,000 before this settlement agreement, $363,000 roughly was David Cohen's obligation.
So let me ask you this. How do you explain this language? This payment schedule deals with only the guarantors. All other provisions of the note shall remain legally effective. Essentially, right? That's what it says. So you're saying to me, even though the parties said nothing about underboss's obligation shall change, and it says that in explicit language in the settlement agreement, that nevertheless the settlement agreement changed the obligations under the note.
I don't think the settlement agreement explicitly says nothing changes. It says
Well, that's what it says. All other provisions of the note shall remain legally effective. I didn't make up that.
That's exactly the point. All other provisions of the note are legal
Right,
effective.
except for how the guarantors are going to pay.
The guarantors were never parties to the note, Your Honor. They were never parties to the note. They're now parties to the note. That's exactly my point.
Thank you.
Thank you.
May it please the court, Your Honor, Daniel Streck from the law office of Oliver Coppell representing respondent Toplin Lingerie. This is a relatively straightforward case. We had a promissory note that was defaulted on. The personal guarantors behind the note were asked to make the guarantee.
How do you respond to your adversary's point that, at least implicitly, there was some sort of amendment reducing Mr. Sasson's obligation?
I will say a few things, Your Honor. First of all, in the settlement agreement itself, it defines principal amount as $800,000. That which was the number under the promissory note itself. That number has never changed. There is language several times throughout the settlement agreement that says we are not providing benefits to a third party, and then nothing alters the obligations of Sasson under the original promissory note and personal guarantee. That language is expressly written into the settlement agreement. I would also submit that this was not a modification of any substantial term of the promissory note. This was a payment schedule. These guarantors, the other two individual defendants, other than Mr. Sasson, owed this money. It was immediately due. What did we agree? You're going to have a much longer period of time to repay this money. And if you bring business to our client, we're going to set off the amount of money that you owe. Because that's how we settle. That's how we're trying to get our money back, because obviously the alternative is coming to court and suing right away for the money that's owed. There is nothing about Mr. Sasson. Mr. Sasson declined to participate in the agreement. So for him to ask for a benefit from the settlement agreement to which he did not participate, to which he offered no value, and which specifically by its terms excludes him directly, I don't think is proper. I think it's contrary to the reading of the agreement. The agreement arose from a situation where these individuals were in default. They owed the $630,000 as their guarantors, and they were given more time. If you do the math adds up to the exact amount that they owed under their portion of the personal guarantee. So that's how I would characterize it, Your Honor. I don't think there's anything that amends the ultimate amount owed by Underboss or by Mr. Sasson under the note. And if there are any further questions, I'll answer them, but I think our brief speaks for itself.
Thank you.
So, Your Honors, I just wanted to point out that the guarantors, Israel Sasson, David Cohen, Joey Esses, they never owed anything under the note. The note was strictly between Underboss and Hopwin Lingerie. The agreement, the personal guarantee is a reactive document. It reacts to the note. I never argued that the personal guarantee changed. I never said we're rewriting the personal guarantee. It only guarantees a percentage. Being that only guarantees a percentage, I don't think we could escape the clear language of the agreement calling this an amendment. Yes, there's language in there saying it doesn't obfuscate or vitiate Israel Sassen's obligations under the personal guarantee, and it didn't. It's still 21.21%. If we supplant that language that says that this is the new payment schedule and this is their obligation, I'm just following the language. I don't see it any other way. If there's no further questions, I'll rest on my arguments in the brief.
Thank you.
Thank you.
Thank you both. Melendez versus 1595 Broadway. Thanks.
Good afternoon, Your Honors, and may it please the Court. My name is Travis Wong from William & Schweitzer & Associates for the plaintiff appellant. As an initial matter, I'm not going to address the arguments made by PCC for the first time on appeal, as plaintiff did not move for summary judgment against PCC, and it's not subject to this order on appeal. As to the order on appeal, it should be reversed because plaintiff established his prima facie entitlement to summary judgment because the ladder that he was using slid out from under him. In response, defendants failed to show that plaintiff was...
Are there issues of fact as to sole proximate cause here?
No, there are none.
Why is that?
Well, first of all, there's no evidence at all that plaintiff misused the ladder. And secondly, there's no evidence that plaintiff was a recalcitrant
Why didn't,
worker.
I mean, at some point he was tied, he had a tie on when he was on the sidewalk bridge?
Oh, at some point he did have a harness?
So then why not when he was coming down? Why?
I mean, defendants never established that plaintiff could use the harness as he was coming down,
So
or
you're
that
saying
he was
there's no tie-off
instructed to.
points? That there are no tie-off points?
There's no evidence that there were tie-off points. There's no evidence at all that plaintiff was ever instructed to use a safety device that he did not use. He was only instructed to use the ladder, and that's exactly what he was doing.
Was the ladder placed before he went on the ladder, or was he the one to find the ladder and erect it?
Somebody else had placed the ladder, and in the cases of Daly and Concepcion that were recently decided by this court, a plaintiff who uses a ladder that was already set up for him can at most be found as contributorily negligent, which is not a defense of the labor law. At the end of the day, this is a case in which the Supreme Court found there to be questions of fact as to the recalcitrant worker defense, even though that language wasn't used. However, under Gallagher, there are 4 elements that need to be met. First of all, the plaintiff must be aware of an available safety device. He must be instructed to use it, chose not to use it for no good reason, and that device must be demonstrated to have to prevent the accident if he had used it.
And is there any evidence that he was instructed as to any safety device that he did not use?
There is none whatsoever. In addition, the 2 cases cited by the Supreme Court, I'm going to start with Kuwaita, which was decided on very specific facts. In that case, plaintiff was using a ladder and he was electrocuted. He didn't remember whether the ladder moved or fell. Therefore, the analysis in that case was about whether the electrocution or the failure of the ladder had caused the fall, and it can't be applied to these facts. Bonksar, in Bonksar, the worker fell from a ladder that he had set up himself, and the defendants demonstrated that he couldn't remember if he had locked the locks on the ladder. In this case, first of all, plaintiff didn't set up the ladder, and defendants have failed to demonstrate that there even were locks on the ladder or tie-off devices available.
Counsel, this is Judge Gonzalez.
Hi, Judge Gonzalez.
Hello. Was the plaintiff's testimony rebutted by any of the witnesses that were allegedly there?
No, there's absolutely no evidence that plaintiff was doing anything other than instructed, that there were other safety devices that he was instructed to use or that were readily available. And if there are no further questions.
I actually have one. Did defendant ever rebut plaintiff's claim that there were, I believe it was 7 witnesses to the accident?
I don't believe so. Okay. Yeah, second question. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Irina Kravchenko, I represent defendants, respondents, 1595 Broadway and Triple Builders. It is the respondent's contention that the Supreme Court correctly denied plaintiff's motion for summary judgment pursuant to 240. It is well settled that as the movement, plaintiff had to establish that there was a violation to begin with, that the ladder was not appropriate safety device.
Didn't the plaintiff testify that the ladder slipped as he descended? And, hold on, let me finish. And wouldn't that be a basis to say that he wasn't provided adequate protection?
Your Honor, what plaintiff actually testified to that the ladder, he indicated, slid straight down and it just collapsed. Taking this in conjunction with his other testimony that he did not actually know if the extension ladder was in a locked position, which it would necessarily have to be.
I'm sorry, but why wouldn't that be contributory negligence in this instance? The ladder was supposed to be the safety device. It didn't act as a safety device. It collapsed, it fell, and regardless of whether it was clipped, if he should have done that, doesn't that go to contributory negligence?
Your Honor, it is the respondent's position that the case law emanating from this court, for instance, a Daly case that was cited by the plaintiff, is distinguishable from the facts of this case, because in Daly, if you look actually beyond the opinion to the record, and I will quote from, this is page 1452 of the Daly record, there was a foreman's testimony in that case, or affidavit, I apologize, who said, I advised plaintiff there would be a scaffold set up for him to work off as well as a ladder in place. I would have the apprentices set up the work devices like the scaffold and the ladder. So under those facts, this court did find that it was comparative for plaintiff not to have checked the locking mechanism. In this case, however, plaintiff testified he didn't know who put the ladder up there, he didn't know how long it has been there, and he didn't see it happen. So there is no reason to believe that this ladder was actually set up for him to use, such that his failure to double-check everything would have been comparative. In this case, there is a question as to whether plaintiff was the sole proximate cause. The ladder could have very well just been stored there, for what we know.
But I you know, respectfully, I don't recall that being the issue. Plaintiff did testify that he followed essentially the instructions of the site safety manager to use the ladder to access the sidewalk bridge. You know, your argument would be stronger maybe if he placed the ladder, but that's not what happened here, correct?
Your Honor, it is the defendant's position that the record shows that the safety manager told him to do the job. The safety manager did not tell him there is a ladder set up for you to use the ladder. Plaintiff indicated—
So you're saying that the safety manager didn't say to access the sidewalk bridge?
She told him to do the job on the sidewalk bridge.
So
she didn't tell him.
hold on. So how is he supposed to do to access the sidewalk bridge except for using the ladder?
By locking it in place. There's other traits on the site. Who knows what the ladder was used for? The evidence doesn't show that it was set up for him.
But did you—
Counsel, is there any testimony that there was a locking mechanism on the ladder?
Your Honor, there's no reason to believe that there wasn't. This ladder was—
No. That's not what I asked you. Is there any testimony, is there anything in the record to indicate that there was a locking mechanism on the ladder?
There's not
Because
expressed—
you keep making reference to it, but I didn't see that.
Your Honor, there is not expressed testimony in that regard, but it is respondent's position that plaintiff, as the movement, had to establish that this ladder, which by default would have had the locking mechanism, didn't have it, and that's why it malfunctioned or was not the proper safety device to get 240 to begin with.
Counsel, did you—
What authority do you have for that?
Oh, go ahead.
I'm sorry.
Sorry. What authority do you have for that?
Authority that there was plaintiff's burden. I mean, this emanates from various cases, but most recently, Justice Stum, in the dissenting opinion in Cutea, pointed out that its plaintiff had the burden of establishing—
Dissenting opinion?
Yes, that was later affirmed.
Dissenting?
I did, yes, but that was affirmed by the Court of Appeals in reliance in large part on the rationale set forth by Justice Stum in the dissenting opinion that the plaintiff has the burden to show that the violation existed in the first place.
Counsel, as I recall, I didn't see any evidence in the record that plaintiff was ever instructed to check the ladder's locking mechanism or to check if the ladder was tied off. Can you point me to where there was any such evidence in the record?
Your Honor, I don't believe there is such evidence, however—
So if there wasn't any such evidence, how can you claim that that was his duty?
It is the respondent's position that for the sole proximate cause argument that there was no requirement to give him explicit instructions that he violated.
Except he also testified that he was instructed by the site safety supervisor to use that ladder. So he was instructed by the site safety supervisor to do something. He did it. And I don't see, I don't recall anything in the record that shows that your people contradicted the evidence that he was so instructed by the site safety supervisor. Was there such evidence?
I see that my time is up. May I answer your question?
Yes.
The plaintiff's testimony was not that he was instructed to use the ladder to do this job. His testimony was simply, I had to do this job, and then he shows up to this location and he sees a ladder. So there is no direct testimony, which is, in our view, distinguishing and controlling in this case. Use this ladder, it's set up for you.
Thank you.
Thank you very much.
Good afternoon, Your Honors. May it please the Court, Abid Bouyan, Wade Clark Mulcahy for Respondent PCC Cleaning Solutions. As the Court is aware, my friend on the other side has conceded that they never moved for summary judgment against my client. I promise I was invited here, but if the Court doesn't have any questions for me, I will rely on my brief.
Thank you.
It seems that Your Honors have a good understanding of the facts of this case, that there is...
Well, I just don't know how there could be sole proximate cause. If someone is instructed to do something, they use a ladder. The ladder, I believe, they were told to use the ladder. There was no one holding the ladder wasn't affixed, and anything else would be contributory. It would go to contributory negligence.
I couldn't say it better myself. There's no evidence that that any safety devices were provided, and I just want to say one final thing is that to not reverse this decision would amount to a massive change in the well-established law that protects plaintiffs from carrying the burden, workers from carrying the burden.
I think we're familiar with the case law.
Understood. Thank you very much.
Thank you. Cruz versus Komatsu America Corp.
Thank you, Your Honor. It's a very quick point, and the only one I really wanted to make was that...
I hope that what you want to make is that there's a case that's already been decided on this issue by
That's exactly the point I wanted to make.
Okay, we're aware of it. Thank you very much.
Thank
Have a
you,
good
Your Honor.
afternoon. Great Lakes versus American Steamship. Yes.
Good afternoon, Your Honors. My name is David Fromm. I represent the defendant appellants, American Steamship Owners Mutual Protection and Indemnity Association and Ship Owners Claims Bureau. I'll refer to them just collectively as the American Club, as we did in our briefs. 48 years ago, in my first year of law school, in the first tort class I took, I learned that in order to have a negligence claim, the plaintiff much so that the defendant owed him or her a specific legal duty. I think we can all agree the law hasn't changed in those 48 years. It's clear that Great Lakes recognized below that its negligence claim was a bogus claim.
That might be the case, Counselor, but frankly, there may be viable claims against American Club based on the fraud claim, which is still, I don't know what the stage that's in, whether it's been replet or not. Correct?
All the claims are gone, all times to
Was the fraud claim dismissed with prejudice?
What?
Or the fraud claim was dismissed with leave to replead, correct?
No, the court specifically said that since they didn't replete it, that they can't replete it.
When did that happen? That, at the time we saw the record, in the record as we saw it, the court gave them leave to replead any fraud-based claims against American Club.
Which they never did.
Well, okay, so are you saying that there's an order subsequent to the order that's before us?
No, what happened was, it was...
Counsel, when is the order that you're talking about?
In their decision, she says that they never pled it. They never repled it.
And? Does she then preclude them from ever repleting it?
No, but.
Okay. She says, I gave you the opportunity to replete and you didn't.
That's correct.
But then there's nothing else that says, and you cannot heretofore replete.
No, but what happened, and it's not in the record, and I appreciate what's not in the record, isn't before the court, but just so Your Honors know, since it was a pre-answer motion to dismiss, we then answered, and they never filed an amended complaint. So I think the case will be effectively over if you dismiss the negligence claim. But I think what I was saying is, before I was asked the initial question by Judge Singh, the down below, when we moved to dismiss, they never argued that my clients owed them a duty. They only argued that the Gordon McCollises owed them a duty. So I think they recognized there were 5 counts in the complaint. That was the 5th count. I think they recognized it was a throw-in. But even if even if there was another valid claim, it's certainly there's not a valid negligence claim. We moved to dismiss also on the grounds of statute of limitations. The Great Lakes concedes that the 3-year statute of limitation applies.
When all the sort of machinations occurred here, which I'm not going to bore you with the details, was the plaintiff ever told precisely what happened, that the policy had been canceled, that the ship had, or the ship had been taken out of service, et cetera, et cetera? Were those,
Well,
excuse me, or did plaintiff discover that in other litigation years later?
Well, there's nothing in the record to indicate that they discovered it in another litigation.
Well, how about the first part of that question? Were they ever directly informed, or was this information passed on to them?
Nothing in the record before this court with respect to that at all. And there's no allegation either in the complaint or anywhere else that they didn't know about it. I mean, I can only tell you what's in the record.
No, but I mean, this is a pre-answered motion to dismiss, and the plaintiffs allege that you concealed this whole thing from them. So don't forget, we're not on summary judgment here. We're required to accept as true.
Absolutely.
So under that circumstance, and it's pretty specific, a court could find that equitable tolling applied, right?
Oh, absolutely not, Your Honor. There's
Well,
nothing.
on a pre-answer motion to dismiss, when the allegations are made and you haven't answered the complaint, why not?
Because there are no allegations, Your Honor.
I think the plaintiff alleges in the complaint that the defendants concealed their scheme and failed to know. Oh, again, I'm sorry, against your client, you're saying.
I'm sorry, I'm not following you, Your Honor.
Are you saying that there are no allegations at all about concealment?
There's general conclusory allegations that they concealed a scheme, but there's nothing specific.
But why isn't that sufficient just now, based on the facts as alleged, essentially that there was a scheme essentially to abandon the ship in Brazil and then cancel the policy after that, so the plaintiff is holding the entire bag?
Well, first of all, the abandonment of the ship was known to everybody. It was known to everybody.
Canceling the insurance?
Excuse me?
How about canceling the insurance?
That's a false issue, Your Honor, because
Why is that
there's
a false
no
issue?
because there is no.
It seems to me a critical issue.
Well, it's the reason it's a false issue is because there was no coverage for this loss under our policy, right? If you look at the rules of the American
But isn't that a separate issue? That's really not the issue before us, is whether or not there's coverage. That presumably, if you're in the case, that could be something that would be decided later. I mean, I don't think.
No, correct, and that's one of our arguments of why this is an impermissible direct action against an insurer.
But again, we have to get back to the stage here, that this is the posture of this case is pre-answer, and what we're just going through quite a lot of facts that demonstrate that they did allege sufficient facts to, at least at this stage, conclude that estoppel should apply here, given what we've been discussing.
With all due respect, I disagree with you, Your Honor, and what I would point out to you is where you're saying they alleged sufficient facts,
At this stage,
right? And if you look at their brief, when they make all these claims of concealment, they don't cite to anything in the record.
But what we're concerned with is just the complaint, not the,
Yes, but you still have to make, so how would you present equitable estoppel? You either present it in your complaint, or you present it in an affidavit. And we're saying that there's no affidavit at all.
But no, it's a motion to dismiss. No affidavit is necessary.
Yes, and then you look to the complaint, and the complaint doesn't have sufficient allegations. They also have to prove that we did something affirmatively.
They don't have to prove anything.
They have to allege.
Thank you.
Right. You're right, Your Honor. They have to allege that we did something affirmatively to prevent them from finding
Did you,
out
again,
facts.
same question I asked you before, did you disclose your cancellation of the policy to the plaintiff?
There's nothing in the record that indicates we did or didn't.
Well, okay.
thank you.
Thank you.
May it please the court, my name is William Bennett from the firm of Blank Rome. I represent the individuals George and Estathos Gordon-Michalis. Sort of draw a picture of where we are. We have a Liberian vessel abandoned in Brazil.
we know where you are.
Well, why are we here in New York then? There's no connection to New York, but for
Where's
But
the
the
American?
American Club, I'm sorry,
Sorry, go ahead, go ahead.
the American Club issues its insurance in New York, and there are ample allegations that both of your individual clients do a lot of business in New York, and in fact, your client, George Gordon-Michalis, is an officer of the American Club, which is based in New York.
And
So
ship owner is also based in New York. Is that not accurate? Ship owner as well?
Yes.
Manages American Club?
Yes. However, my individual clients are the owners of Phoenix Shipping, which is the ship manager. That client is the owner of the vessel.
The allegation is that your clients are the beneficial owner of the vessel. And we, at this point, must assume for the purposes of this motion the truth of that allegation. It may be borne out in discovery that that's incorrect.
Which it already has in other federal cases. But here's the bottom line is,
Now, we can't look at those, counsel. What we're looking at here is the complaint. So if you would be
I'd like to answer-
excuse me, if you would be so kind as to stick to that and not tell us what's in
I
the
will.
record of other cases, that would be more helpful.
I will. In the complaint, there's a notation that the Gordon-Michalises, on behalf of the ship owner, contacted the Greek-based broker, who then reported the claim to the New York American Club office. It was the American Club that decided that because Brazil is in the same time zone as the American Club's office in New York, that they'll take the claim from Greece and bring it to New York. My client had no influence over that.
Even though your client is an officer of the American Club.
My client is not an officer of the American Club. He is on the board of directors of the American Club.
He chairs the board?
and the law is-
Counsel, may I just, does he chair the board of the American
He did not chair
Club?
the board at that time. And here's the other thing. The law is in my client's favor in a sense that, yes, you may have contacts in New York. That's step one. Step two is, do those contacts have a connection to the claim that they're making? And it doesn't.
Well, the claim, hold on. So the claim here is that there was a cancellation, that there was essentially either a fraudulent cancellation, there's a cancellation of a policy in New York that was caused by your client. That's how I read this record. And that seems to me—
That's not the claim.
Respectfully, that seems to me that there's a basis for jurisdiction, that your client was engaged in the American Club in the cancellation of that policy.
That's not the claim. The claim is that my client was negligent, which resulted in the abandonment of the vessel, which automatically cancels cover. Because we're not dealing with an insurance policy, we're dealing with a P&I mutual. The ship owners, it's a totally different vehicle.
Right,
It
and so the
automatically
counsel-
all that is public knowledge.
Counsel?
Yes.
So then the allegations of the complaint are that all the things that your client did, or many of the meetings and transactions, and to create that negligence claim, to fail to follow anything that the Brazilian authorities required the ship to do, happened in New York. You might dispute that as a matter of let's take everybody's deposition and see if that's true. But that's what the allegations are. Again, we are on a pre-answer motion to dismiss.
I get it. His burden of proof
Is
is
just to
outline,
make allegations that you had these meetings. and
not
these-
bold-faced allegations with no substance to them.
Okay, but, all right, but
And he
fair
was
enough,
able-
take some depositions and then say, no, we did nothing. We were in Greece the entire time. We weren't in New York at all, and then move for summary judgment. But on a pre-answer
Your Honor, they
motion
failed on
to
4 federal actions
dismiss,
already.
Yes, but we can't look to those. I mean, we,
Understood.
okay,
Understood,
all
but-
right, well then.
But the claim is time barred. As a result of that, they knew back in 2014 that my client was involved in this. Here's the point is, we did not do anything to force them or induce them to do nothing. And that's why the claim is time barred. Thank you.
Thank you.
Is he the Prague Beach guy? Pardon? Is he the guy admitted Prague Beach guy?
No. I can't remember.
Good afternoon, Your Honors. Britton Sparkman, Chalice & Co. PC.
Counsel, can you tell me what's happening with, at least my understanding from the record is that you were given leave to replead the fraud claim. Is that correct?
Yes, Your Honor.
And did you move to replead the fraud claim?
Plaintiff has not moved to replead the fraud
So
claim.
are you barred now from moving to replead the fraud claim?
I'm not sure that it's barred, but I think that it would be a fight.
You think that it
A
would be...
fight
Yes, Your Honor.
to replead?
Is
Is there an order that says
There's no
you
order
cannot
on it
replead?
currently. There's not an order on it, but
you believe
since
it's-
answers have been filed, we'd have to move in order to replead. So I'm sure that would be opposed, so. One point that I would like to make.
So may I start by asking you, where do you find a basis for a duty between the two insurance companies?
Right, so our client steps in as the subrogated insurer on behalf of Pacific Gulf, who were the charterers of the vessel, the Adamastos. The cancellation of the insurance policy as a result of the change in manager was never provided, no notice was ever
Again, let me
provided.
just ask you, what allegations give rise to a duty? It either has to be contractual, which you don't
Right.
have. It has to be based on common law or a statute, which you haven't pled. So again, I'm trying to figure out, these are two insurance companies. They don't know. In fact, they're mostly antagonistic towards each other, correct? So where is there a duty from one to the other?
The duty arises in connection with the fact that the vessel was insured in the first place. And so what we've pled in the complaint.
So in other words, what you're,
doesn't give-
I'm sorry.
Go ahead.
So the duty, essentially what you're saying, I mean, it seems like an unlimited duty. So every time you write, an insurance company writes coverage for a vessel, there's automatically a tort duty? I mean, can you imagine how broad that duty is going to be?
Well understood. It's not every single time. But we do believe
What
that
makes it special in this case?
What makes it special in this case is because of the knowledge that the parties had with respect to the condition of the vessel at the time that the insurance policy was applied for in New York and was obtained and issued. And
At what point did that duty arise under your theory?
the duties arose under our theory at the time that the issuance and then subsequent cancellation of the policy as a result of a change in the management company, which was.
So wait.
The cancellation of the policy by American Club then created a duty between American Club and Great Lakes? Where does that duty come from, either under common law or tort law or contract or something else?
We believe that it's a common law duty is what we've pled.
Have you cited any cases, counsel, to support that kind of duty? I mean, there are a lot of insurance companies that co-insure, and I've never seen a case where we would hold that co-insurers owe tort duties to each other or duties of negligence duties. So do you have any cases where you found that to be true?
I don't have any cases beyond.
Doesn't it sound like, counsel, that maybe you have a fraud claim here, but it's not a negligence claim? And that, in fact, what you're attempting to do is just do a runaround 3420 by asserting a negligence duty when there really isn't one that's been recognized by any courts?
I don't think so, Your Honor, and I would also argue that we do believe that we also have a valid basis for the unjust enrichment claim.
Well,
But
You know,
you
you
didn't
may
appeal
have-
from that.
Yeah.
Correct,
But if you didn't appeal from that, how can we reach it? You may well, maybe you did have a claim, but in the absence of a notice of appeal from that part of the decision, from that part of the court's order, how are we supposed to reach it? I don't think you addressed that in your brief, as I recall.
No, Your Honor, simply because the court made a finding that it was subsumed under the negligence cause of action.
But
I mean,
you
we
didn't
see-
cross appeal, right?
I'm sorry, I did
There
not
is
hear.
no cross appeal, correct?
Correct, Your Honor.
So how are we supposed to reach that?
Understood, Your Honor.
I mean, we see that you have, obviously, American was insuring this vessel.
Right.
And then Great Lakes was insuring this vessel. And once American pulled out, canceled the insurance, Great Lakes is there holding the bag. You know, something seems awry there since the vessel didn't seem to be seaworthy in the first place, and there are a number of different issues with regard to that. But how does now one insurance company have a claim against the other insurance company under those circumstances? I mean, are there other facts? Those are the facts.
Well, those are the primary facts, and if I could just answer that while also addressing the time bar issue, the specific pull of the coverage as it was related to the January 7th notification to the Greek government that we're no longer going to serve as managers was concocted in a manner in which to have an automatic cancellation of the policy under rules that was not known to our client or to, and in fact, in the allegations of the complaint, notice wasn't even provided to the owner of the vessel and subsequent to our clients insured, the charterers of the vessel.
I see that with regard to your claim of estoppel and the statute of limitations. I still don't see what connects these two independent insurance companies. And it's been asked several times, so I'm not going to belabor the point.
Yes, Your Honor. I think that, just in summation and wrapping up, I think that the connection is through the Gordon McCallis brothers and specifically George.
I'm sorry?
Brothers.
Is through the other defendants in this case, George Gordon McCallis, and with respect to the actions that were taken in order to cause this vessel to be effectively abandoned in Brazil.
doesn't that sound more like fraud, again?
Thank you, Your Honor. Understood.
Thank you.
Thank you.
Thank you for the opportunity to reply. I just want to briefly address the statute of limitations issue again. In order to establish equitable tolling, the plaintiff has to allege, and not prove, allege, I recognize that they filed the complaint in the wrong forum, or the defendant actively misled them, or the plaintiff in some extraordinary way had been prevented from complying with the limitation period. None of that's pled in the complaint. In fact, I had an opportunity to look at the complaint while the other lawyers were presenting their arguments. Concealment, there's nothing about concealment in the complaint. So I think that it's very clear, based on the allegations of the complaint, and that's it, not what they write in their brief, not what they said in oral argument. Based on those allegations, it's clear that this case was not filed within the applicable 3-year statute of limitations, and that the equitable tolling is not a lifesaver for their claim. Thank you very much.
Thank you.
I rest on the papers I submitted, but if you have any additional questions.
I think we're good. Thank you
Thank
very
you.
much. Thank you all. People versus Luis Vargas.
Good afternoon, Your Honors. My name is Sarah Chaudhry, and I represent Appellant Luis Vargas. Mr. Vargas is before this court seeking review of the lower court's summary denial of his suppression papers. This, by way of background, Mr. Vargas was arrested for selling a small quantity, $20 worth of cocaine, to an undercover officer and raised two material factual disputes regarding this arrest. First,
Did the defendant sufficiently address the factual issues and claims that were made by the prosecution here with regard to the sale of this drug?
Well, first of all, Your Honor, the prosecution's papers were quite threadbare. They didn't have any information other than the fact that Mr. Vargas apparently engaged in a telephone conversation with an undercover officer in order to set up this sale. The prosecution also stated that both the offense and the seizure occurred at the exact same moment, 4:44 p.m. In response to that, Mr. Vargas stated that he was engaged in no observable unlawful behavior at the time of the seizure.
How about the first part, though, the arrangement part? What did he controvert that issue?
So, Your Honor, I don't think that Mr. Vargas was required to controvert that part because that didn't really go to whether or not that there was probable cause for his arrest. So, for instance, just by way of a hypothetical, we can assume that, perhaps somebody makes a phone call and decides to engage in some kind of drug transaction, gets to the location and determines that they don't really want to follow through with that. So if Mr. Vargas were to assert, I did not engage in that phone call, that wouldn't necessarily create a material factual dispute. Here, because it's a buy and bust case, he either had to deny the transaction at issue, which he essentially does by stating that he was not engaging in unlawful behavior at the time of the seizure as well as preceding the seizure, that he was simply walking down the street, and that there was nothing illegal or suspicious in view when he was approached by the police. Now, typically, in a buy and bust case, such a claim of lawful conduct at the time of seizure does not suffice to create a material factual dispute. However, in these factual circumstances, where the prosecution provided little information and the information that they did provide stated that the seizure and the offense occurred simultaneously, Mr. Vargas's allegation of lawful conduct at the time of the offense and the seizure was tantamount to a denial of engaging in the drug transaction.
It seems to me in many of these cases that we've decided, the allegations made in support of the motion are more specific. I did not engage in a sale of drugs at that time, as opposed to I did not engage in unlawful conduct at that time. It seems, why isn't, could you tell us if there's any case law that supports as broad a statement as the one here? I didn't see anything that supported that.
So this court in People v. Bailey actually was looking at a substantially similar factual scenario, a buy and bust case where the defendant, like Mr. Vargas, stated that he was not engaging in illegal or suspicious activity at the time of the seizure. This court determined that because the seizure and the offense were nearly simultaneous, that these allegations, which are similar to the ones Mr. Vargas made, were tantamount to a denial of the drug transaction. So that is, precedential, and it is a decision that this court has issued. And given these specific factual circumstances, where, this is not the typical situation where you're saying that there was no unlawful conduct at the time of seizure. Okay, but the drug arrest maybe happened prior, and you haven't addressed that. But Mr. Vargas addressed that as well.
With the unlawful conduct in this case, couldn't you argue that it occurred at the time the phone call was made as opposed to later on and maybe then he changed his mind going through with it?
I mean, you could argue that, but I don't think that would create probable cause for his arrest. I think the issue here is, did he raise material factual disputes that would necessitate a hearing? When we review it in context of the prosecution's papers, it wasn't incumbent on him to counter every specific fact the prosecution set forth. And Your Honor, I would submit that even if he were to say in his papers, I didn't make that phone call, that wouldn't go to whether or not there was probable cause for his arrest. And there could be a situation, which I'm not conceding here, but as I noted, there could be a situation where you make a phone call and you don't follow through with that. Then there's no basis for your arrest. He did what he was supposed to hear. He said, I did not engage in unlawful conduct at the time of the offense and seizure, and in the period preceding. I was walking down the street. There was nothing illegal. There was nothing suspicious. That should have granted him a MAP hearing. And this is, obviously because of also the way that the prosecution has detailed the facts. When this court confronted the same exact, or rather I shouldn't say that, a nearly identical factual scenario, it found that the allegations similar to Mr. Vargas's were sufficient to have warranted a MAP hearing.
Thank you.
Okay, I don't know if, do I have a moment to speak? I don't know if my time's out, or I could.
No, the red light means your time is up, but you have rebuttal.
Okay, thank you.
Good afternoon, Your Honors, and may it please the Court. Bridget White for the people.
So, counsel, why isn't it sufficient here, the allegations that were made, where the complaint states that the arrest and the sale were made at 4:40, at the 4:44, whatever it was, it's the same time. I mean, it wasn't detailed. I don't know that that's accurate, that the sale and the arrest could be made at the same time.
Well, Your Honor, I would argue that it's important to note that the prosecution's papers, in every instance in which the time was listed, noted that that time was an approximate time. This was a fast-paced transaction.
So it's not perfectly detailed, in other words.
As to the time, I think it gives enough for the defendant certainly to deny the allegations of criminal conduct. As to the time, there may be approximation, but I think this likely did happen in quick succession. But what I think is really critical here is the extended timeline, which includes the phone call.
Oh, does your adversary argues that portion of this incident doesn't go to probable cause. Is that correct, or you disagree?
I think it alone would not create probable cause, but I think it's part of the commission of the crime. So it's a critical fact that's gathering the packaging of the drugs, the going to the location. That's all part of the timeline of the crime. And I would just like to point out that my adversary makes reference to the lack of detail, alleged lack of detail in the papers, but these were facts within defendant's control. He would know whether he engaged in that phone call. He would know whether he packaged the drugs and went to the agreed upon location. So there was nothing, if there's any deficiency in the prosecution's papers, which I argue there's not, it would do nothing to undercut defendant's burden to produce the facts within his control.
Well, how many facts, how detailed do his facts have to be other than just saying, I wasn't that person?
Well, Your Honor, I think he failed to do even that, because all he alleged here was that he was walking in the vicinity, he wasn't engaged in observable unlawful conduct at the time of the seizure. It would have been extremely easy for defendant to say, I did not engage in a drugs transaction that day. And as Your Honor pointed out, that is in the majority of cases under this area, the defendant will say at least that.
So, and counsel, in the felony complaint, it specifically said, that the defendant spoke to the undercover to arrange the sale, correct?
That's correct.
And he didn't controvert that at all in his motion to suppress, correct?
That's correct. He made no mention of the fact that the sale was prearranged, that he spoke with the undercover officer on the phone, any of those details. He ignored them. Just to the defendant's second argument, he very clearly failed to meet his burden under People v. Jones. He was required to allege any facts. He alleged none. And so for those reasons, if Your Honors have no further questions, we would ask that you affirm.
Thank you.
Okay, so as an initial matter, I would direct the court again to People v. Bailey, where the court confronted this kind of factual scenario and determined that even something that may be considered bare bones would suffice to create a factual dispute where we have the facts that the seizure and the offense occurred at the same time. Second, the fact that the prosecution's papers themselves were internally contradictory should have warranted a MAP hearing in and of itself. There was a lack of detail, but also the detail that was disclosed was contradictory in that the prosecution stated, and now it does state that, well, 4:44 is maybe an approximate time, but I would submit to you that a very specific time of 4:44 listed as both the seizure and offense, that seems to be the prosecution indicating that this happened at the same time. There are many VDFs that I know that we all have seen, and they are able to create a better factual scenario by putting the actual approximate times. Two, there's this issue of why didn't Mr. Vargas say anything about the undercover phone call? And again, He could have. It was not incumbent on him, though, and it would not have been what was necessary in order for him to have a hearing here. So in People v. Bennett, this court noted that it's not necessary that a moving defendant raise an issue as to every factual allegation put forth. In other instances where the people have argued that a defendant should have controverted a phone call or pre-recorded buy money.
But it was the phone call, but wasn't it the phone call that sort of triggered the entire transaction? And so it seems, I don't know, unusual not to look at that part as well, but rather it should be looked at as a whole to make that determination, no?
Well, a defendant doesn't have to prove, obviously we all know, the defendant doesn't have to prove their whole case when they're doing a motion to suppress,
No, they have to just
right?
controvert.
Right.
You have to raise an issue.
They have to raise an issue of material fact. Mr. Vargas did that here. He could have addressed each and every, which was very few, allegation, but that wasn't his burden.
I just want to take you back. I know the red light is on, but with regard to People versus Bailey, some of those other cases that involve just observation cases where the probable cause was based on the observation, but here it's based on an undercover buy and bust. Isn't that different?
Yeah, I hear what you're saying, Yara. It's a slightly different factual scenario, but the court's decision there was just simply that because the seizure and offense sort of occurred did occur simultaneously, the fact that you say that the fact that the seizure and the offense occurred simultaneously, a defendant's seemingly bare-bone allegations were tantamount to a denial of the drug transaction. So that's what we have here as well, regardless of the fact that there was this phone call. If we're assessing just the sufficiency of the factual allegations, if that was sufficient in Bailey, it should be sufficient here as well.
Okay, thank you.
Thank you.
Thank you both. Lizardos, Inc. versus Baja Lounge. You may proceed, counsel.
Thank you. Good afternoon, Your Honors, and may it please the Court. The law in this state has long held that no court should be required to serve as a paymaster of the wages of crime or the referee between thieves, and therefore the law will not extend its aid to either of the parties or listen to their complaints against each other, but will leave them where their own acts have placed them.
Did you note your appearance? I'm sorry.
I did not. I jumped the gun. For the appellants, my name is Scott Benjamin for the law firm of Andreas Vassilatos. Apologize for that. But as I noted, the law of the state is that the courts are not to intervene where there is essentially a dispute between two people who have committed criminal acts.
How does that interplay with the breach of contract claim? Because that's what the ex-wife's claim is for breach of contract.
Well,
the fact that both parties, and I would submit where your client ends up incarcerated, why should that take away the right of a party to sue for breach of contract?
Well, what she's suing for, what she claims she's suing for, is that she wants a percentage of ownership of a bar restaurant that holds a liquor license. She is a convicted felon. She is not permitted by law to own.
That's true of your client as well, correct?
I'm sorry?
But that's true of your client as well, that
It is
he's a
true of-
convicted
it is true of
felon
both
and has no
parties.
right, excuse me, and has no right to title to.
It is true of both parties, but to the extent that my client has ownership interest in a business that holds a liquor license, that's a problem that's between him and the state liquor authority. But in terms of the
So
dispute,
why can't we make the same argument with respect to the wife? That's an issue, that would be an issue between her. She might have to make an application and they'd make a determination. It seems to me that, that you both are, you fall on this issue together, both.
well, the court says, the Court of Appeals in Stone versus Freeman says that where two wrongdoers are entered into a contract, the court will leave them where they stand. So in other words, right
But
now,
I believe there's something where you have agreed that she has a certain percentage of Baja. I have to check to find out.
I don't believe that we've ever agreed that she has
Counsel,
that
this
percentage.
is Judge Gonzalez.
Oh,
So,
yes.
so don't we have some admissions with respect to your client? I mean, didn't your client sign a tax return in 2015 that said that his ex-wife was the 85%? I don't know if she was the wife at the time or ex-wife at the time, but 85% owner. Isn't that problematic?
I don't have that point, but what I would say is that she signed tax
It's in-
returns. She has signed
It's-
tax returns stating that she is not an owner, that she's an employee.
Your client did as well. Record 434 signed the tax return saying that she was the 85% owner.
Well, what we know, she contends that she's a 40% owner, so we know that the 85% number is wrong. But again,
So how are you entitled to summary judgment, counsel, under these circumstances?
well, we believe that we're entitled to summary judgment in our motion papers. We outline all of the 13 causes of action. I'm not going to address each of them severally. But the two key points is that she, as a convicted felon, has no right to claim a contract that, I'm sorry, she has no right.
Counsel, I'm going to stop you there. I'm going to stop you there for a moment. You have two people who you highlight the wife's criminal conviction, her felony conviction. You, of course, are not highlighting your client's felony conviction. But isn't this the kind of situation, the kind of scenario that needs a fact finder to determine credibility?
Well, no.
Especially given the documentation that includes party admissions.
Because our position is that given there was never a written contract between them, so it's an oral contract, and the contract is devoid of any specificity of what was to happen, and that's in the record. And the other thing is that the consideration is past consideration. So in other words, the monies that allegedly changed hands, the wife claims that she handed over various sums of money, part of which were the proceeds of a car that they had held jointly from the insurance when the car had been stolen. Those monies were changed hands before any alleged agreement was made to the effect of you'll be a 40% owner or you'll be a whatever percent owner.
But I mean, but counsel, the plaintiff has a completely different story, right? So we're not allowed to fact find on summary judgment. And with respect to the breach of contract claim, let me just, okay, I'm not going to dispute whether or not we can fact find on summary judgment, but why can't we just award money damages on the breach of contract claim, which we normally do? And then let her, if she wants to sue for specific performance, that's a whole nother thing.
Well, there's two reasons. The contract, to the extent that there was any agreement, it's past consideration.
All right, but let's assume that there's a factual dispute about that.
But there's
You're
not.
saying to me we can't enforce the contract.
But there's not a factual dispute about that. The plaintiff concedes that there was no further money changed hands after what she claims is the discussion by which she was promised 40%.
Okay. Thank you.
So,
Thank you. You can finish up on rebuttal. Thanks.
On the rebuttal. Thank you.
Good afternoon, Your Honors. Jason Matuskevitz on behalf of the respondents, Lizardos and Anna Liz. Just a few months ago, I was before this very court arguing this very issue.
Counsel, I have a very specific question. In your 13th cause of action, you seek attorney's fees. I didn't see either an allegation of a contract or a statute on which you based your claim for attorney's fees. What is your basis for a claim for attorney's fees?
I believe that the basis of the claim for attorney's fees is probably not based on contract or statute. And
so what is it? But under the American rule, you need one of those.
Yes, that's correct,
What
Your
is
Honor.
the basis for your claim for attorney's fees?
Your Honor, I do not recall specifically whether that was decided on summary judgment, but if it was not appealed. The claim for attorney's fees was not.
Are you agreeing that has no merit?
Yes, I am, Your Honor.
I see. Thank you.
Is your adversary correct that the law of New York is that because both parties have felony convictions, that they've essentially given up their rights to breach a contract against each other?
Absolutely not. And as this court just recently held, this is a regulatory statute. It's merely malum prohibitum, not malum in se, was the specific language that the court used. And you can't ignore the relative culpability of the parties. In the case law, the court has said that equity is not a roving marauder. Equity is not a Puritan. Equity doesn't seek to punish, it seeks justice. The
Is there
result.
any allegation, counsel, that your client was, counsel, is there any allegation that your client was either managing the business or selling liquor?
There is an allegation that she was briefly appointed to be the receiver of the restaurant for a period of time. I believe it was in 2018, and they've alleged that she mismanaged it. That is in their counterclaims, which ironically, they don't mention his felony conviction being a bar to their own counterclaims.
Counsel, can you address the failure of consideration argument that counsel is making, that the consideration was past consideration and therefore isn't sufficient to support a breach of contract claim?
You're talking about the seed money that they...
I guess that's what counsel's speaking about, yeah.
Yeah, so this goes to the issue that this is summary judgment, not a trial.
Well, counsel says that your client doesn't dispute that there was consideration, that your client admits that there wasn't consideration. So how
there is no such admission in this record. And they do like to say that issues are uncontroverted. However, saying that it's uncontroverted doesn't make it so, nor does it entitle a party to summary judgment. The simple fact of the matter is this is a husband and wife who owned 3 restaurants who are working together to ensure the success of those restaurants. The consideration was...
Former husband and wife?
I'm sorry, former husband and wife. Yes, they are divorced. But at the time, they were husband and wife up to a point. And I do believe that they were working together after they were divorced for a period of time as well. But that just underscores the need for a trial in this case. Because frankly, the facts aren't that exceptionally well developed either in the deposition or in the motion for summary judgment.
Thank you.
Thank you.
If I could just respond to a couple of points. In their respondent's brief, they make reference to a case called Napolitano as being sort of standing in opposition to the proposition that that no honor among thieves thing that I said at the beginning. In the Napolitano case, the person who was suing for breach of contract, he never worked in the bar, managed the bar, or served liquor in the bar. That case is entirely distinguishable from this case because in the Napolitano case, he was acting as an outside consultant, even though he had a criminal conviction. He was acting as a consultant, teaching them the ropes about how to run a bar operation, and he was seeking his compensation for those services. There's nothing about the Alcohol Beverage and Control Act that prohibits that, and because that activity was not prohibited, that's why he was permitted recovery, because there was nothing in his cause of action that would have compelled this court to make him or to treat him as an owner of a liquor license holding business.
So, counsel, let me interrupt you. This is Judge Gonzalez. So I'm sure you've heard of the premise that what's good for the goose is good for the gander. How does that not apply to the former wife?
Well, again, she's the one who's coming to court seeking relief, and under the law, it says that the court will not, Stone versus Freeman, the court will not act as a paymaster between thieves, and so the law will leave them where they found themselves. So if my client has a problem, it's not a problem.
I don't understand. Isn't your client accused of pilfering the funds of the, what is it, of Lizardo's and transferring them elsewhere?
Right, but if it's his own business, he can do whatever he wants with the money. In other words, if it was never the wife's business, it's not her position that she has a right to complain about that. So if he took money from the initial business and put it into a second business, he's permitted to do that.
She conceded, at least in one tax return, that she had an 85% interest in one of the businesses. How do you get away from that? And why doesn't that create an issue of fact?
Well, I think that there are other issues of fact that stand in the way of that, one of which, I'm sorry, not issues of fact, issues of law.
Thank you, counsel. I think we have your argument.
Thank you for your time.
Thank you both. Valbuena versus 395 Hudson, New York.
May it please the court, Michael J. Kazoras from the law offices of Eric D. Feldman on behalf of...
Just a minute, counsel. Someone should come over, sit at this table right within the well. Whoever's arguing first, yes.
Who's on deck?
Who's on deck? Okay, why don't you start again?
Okay, and I represent...
Just a moment, because you started before I told you. Okay, go ahead.
I represent the appellant respondent MBI Group. Just as an initial matter, I want to point out that the plaintiff has agreed that the 240 sub 1 claim was properly dismissed. With regard to the 241 sub 6 claim, I know there's been a lot of back and forth about the issue of the Masonite being an integral part of the work, and that was the basis for the Supreme Court's decision in dismissing that claim. However, I don't think we even get there. This court doesn't even have to address that issue because this is not a labor law case. 241-6 doesn't apply because the plaintiff was not a mechanic.
But didn't the plaintiff testify that, in fact, that she was picking up debris, construction debris? And I understand, you know, that other than her testimony, there's really nothing much else about that. Is that sufficient in itself, her testimony, to create some kind of issue of fact?
I don't think it does, Your Honor. Her incorrect subjective belief that she was there to pick up construction debris when her employer told her not to pick up construction debris. My client testified that they had no reason to be interacting with the janitorial contractor. MBI Group had a separate subcontractor that was there specifically to pick up construction debris.
And in fact, at the time she fell, was she even engaged in picking up construction debris?
No, that was another point I wish to make, Your Honor. Even if we take the plaintiff's testimony as correct that she was told to pick up the construction debris, the fact of the matter is that she was not even going to pick up the construction debris and was not picking up the construction debris at the time of her accident. She was following a security guard that was working on the 9th floor that was not hired by my client to go pick up regular office trash that was in the office of a gentleman by the name of Scott Danielson, who was an office worker for a tenant on that floor.
So all of that is to say that this is not a 241-6, it's not a labor law, it's a negligence action or a 200.
Correct, Your Honor. And with respect to those latter points, the 200 and the common law negligence claim, the Supreme Court, we believe, correctly held that we did not have notice of the condition, but we were held in on the case under the theory that we directed the means and methods of the plaintiff's work.
Well, this is not a means and, may I just finish? This is not a means and methods case, but isn't it a dangerous conditions case?
Well, Your Honor, I can address that now or I can address it on rebuttal since I'm a respondent on that point.
Okay. Then let's hear from Judge Gonzalez, who had a question.
Right, thank you. So I'm over here.
Hi.
So I did want to address the Section 200 claim and the negligence claim that claim that are raised. So we know that under Section 200, protection isn't limited to those who are injured in the performance of construction work, right? That's the Court of Appeals said that in Jock.
Well,
here,
they also said...
You referenced, may I, counsel?
Yes.
Here you referenced the testimony of the security guard, Michael Flanagan. He's the person who said that he buzzed the plaintiff through the door into the hallway between the two office areas, and that's where the injury occurred. Am I right so far?
Yes.
Okay, so how does Section 200 not apply here, where you have Masonite boards that are in the hallway and that are put together with masking tape instead of duct tape.
So this is the issue you were going to wait to address? You wanted to wait to address the 200 issue?
I can, or I can address it now.
You should wait to address it, and that's why I didn't
I see the red light.
let you answer before. Okay, thanks.
We'll wait.
May it please the court, Glenn Kaminsky with the firm Omni Demers McManus, counsel for respondent appellant 395 Hudson. And we would ask this court respectfully to affirm the decision, at least as it pertains to Hudson. It's long been held that the absence of evidence demonstrating how long a condition has existed prior to plaintiff's accident constitutes a failure to establish the existence.
I'm sorry, but I just want to get to a question here. As Hudson, you're the owner, and so with regard to the 200, dangerous condition is relevant. That's an issue. And you have an employee who was deposed who indicated that it didn't, there was, with regard to photos, I think he saw, that the boards, masonite boards, were not properly affixed, that they were using masking tape, I think, instead of duct tape, and that he was reviewing. Am I correct on that?
I don't believe that's Mr. Basel's testimony. No, he did, under questioning from Ms. Sachs, did testify as to the photographs, some which he could identify, some he could not. It seemed to me he was just identifying that this is the 9th floor of the area. But I think what we do know about all the facts, and every witness that testified, is no one had complaints about this masonite that's been laid down. The plaintiff had no complaints despite working there Monday through Friday for 4 weeks prior. Mr. Flanagan, who walked the masonite moments before the plaintiff, never had any problems. And in fact, right after the fall, went back and said, well, I saw a very small gap, less than 1/2 an inch. That's at 1016, 1017 of the record.
Mr. Bazile does indicate that he never inspected the boards that caused plaintiff's injuries. So how would he be aware? I mean, he should be, as the owner, he's supposed to be aware of any dangerous condition that exists. If you have the property manager not inspecting, how are you able to argue that you're not responsible for a dangerous condition? Or
just as the court did below, citing the early case, which we cited, it cited the record 15, we cite in our reply brief at 9 and 10. That is a case on summary judgment that has the long-standing rule that if there's no evidence of this condition existing.
But there is evidence. There's testimony in the record that that the condition existed.
Respectfully, I disagree that there is no evidence of this.
So, counsel, the project manager, Daniel Blackall, he's the one who said that there was white masking tape that was used and that the industry standard was a 3-inch wide duct tape. Okay, that's one. But then you have the other issue, which has to do with Mr. Bazile, or I don't know how you say it, Basil?
Basil, maybe?
Yeah, he simply bypassed the 9th floor, even though he did a walkthrough, according to his testimony, every single day. And I believe it was he who said that so long as there were offices in occupancy, it was his obligation to inspect. Here, there is testimony that there were offices in occupancy on either side of the hallway. So how do you figure that out?
Okay, so if we're assuming Mr. Basil, whatever, did inspect, he did walk through, this general inspection doesn't create constructive notice of the dangerous, of an allegedly dangerous condition.
Let me stop you.
What happens if you omit inspection?
If you
fail to inspect?
Well, again, because there's no evidence of the dangerous condition existing, I look at the early case relied upon by the court. It's not needed, but even if inspection is needed,
if you don't look,
even if inspection's
not
needed.
Counsel, I have 2 questions here, one from Justice Gonzalez and one from Justice Singh. So if you just wait a minute, let Justice Gonzalez answer the question. I think she didn't hear. Go ahead.
Your Honor.
You know what? I'm saying, does it get you off the hook if you fail to inspect? Is the omission of a duty to inspect, of an admitted duty to inspect, does that get you off the hook?
I'm having a little trouble handling the question as it's worded, but I will say this, that nothing that Mr. Basile said put us on the hook, okay? And in fact, what I found with the inspections, and if you look at Mr. Blackall's testimony, that they ongoingly inspected it because it was their job to do so. Mr. Crow said he walked through daily at the end of each day to inspect for safety. So it was inspected on a daily basis, and every witness testifies over and over again, no complaints, no complaints, no complaints.
We have a question from Justice Singh.
Just quickly, you keep saying that there's no really issues with respect to the boards, but my recollection of the record is that Mr. Lino, after the accident, went there and he saw a discrepancy of 3 to 5 inches, which of course is disputed by Flanagan. Flanagan sees that it's about a 1/4 inch gap. Isn't that testimony in itself sufficient to show that there could be a dangerous condition there? And finally, it's your burden on summary judgment to establish a prima facie case. And I submit to you, it's hard to see how you've done that here.
And since you've paused a little bit, I just want to add, and you mentioned that Blackwell inspected it constantly and nobody found anything, but he inspected it constantly and didn't notice until deposition when he was shown the pictures that the proper means for putting this board down was not used. So anyway, answered that question. I just
part of that's a red herring because plaintiff doesn't testify that it's a problem with tape. So we're talking about tape, but the plaintiff testifies there was no tape on this particular board.
But the main part of the question
Justice
was
Singh's question about Lino, this is post-accident. So what happened post-accident? What it looks like post-accident doesn't mean that's what it looked like pre-accident. In pre-accident, we know this, everyone testifies there's no complaints about it.
Okay.
Thank you.
Thank you.
Good afternoon, Your Honors. Beth Gehrig for the Plaintiff Respondent Appellant. You've addressed a lot of my arguments here on the 200 claim. So I would just like to clarify a couple of things. I believe that the sum and substance of the argument that I heard is that the panel understands that the defendants did not make their prima facie showing. On the 200 claim, they had to show what the condition of that area was like when it was last inspected, and there is nothing in the record from any witness from the defendant saying when they last inspected it and what it looked like at the time.
What about the 241-6 claim?
And the 241-6 claim, the trial court only addressed the inherent in the work. And as far as the inherent and the integral to the work defense, I think that the interesting thing here is that we have and I don't want to destroy the name of the case, Krasanskowski case. And in that case, the moving parties relied on that for the argument that the masonite was integral to the work, and therefore it was not an actionable condition. But the interesting thing in that case, it opens up the door to whether or not masonite, which is laid down, can be integral to the work when it's not in the proper condition needed to be able to be used. Here,
well, this was just to protect the carpet. So it's put on the carpet so that nothing else gets on the carpet.
Respectfully, Your Honor, not Judge Blackwell, sorry. Respectfully, Your Honor, Mr. Blackwell had testified at page 1163 of the record that the masonite was for trade access so that they could put the mini containers and roll them through the area. If there's a 3 or a 5-inch discrepancy, they're not going to be able to roll it through the area.
But that doesn't go to the integral to the work, because integral to the work means that it's used for the purpose for which they're saying that they used it to protect. That's part of the work that they're doing. I don't see how you've disposed of that issue.
In the Sinai case, this court had defined integral to the work as follows. Integral to the work defense applies when eliminating the alleged defective condition would be impractical and contrary to the very work at hand and inconsistent with accomplishing a task that was an integral part of the job. Here, because it was warped, it couldn't be used, just like the second department case in Giza. In Giza, they found when the masonite was warped, it was not integral to the work.
But doesn't, you know, I know, well, the second department, I'm not sure we follow that, but aren't you, what you're really arguing to me, or at least what I'm hearing, is dangerous condition? That's, but that's what that argument sounds to me, that what you're arguing is dangerous condition, really a 200 claim as opposed to whether or not it's integral. Clearly, it was put down to protect the carpet from the renovation construction going on.
I agree. I think as far as the condition that the masonite was in, it falls under both the 241-6 because they're raising the integral to the work, and absolutely, this was a dangerous condition, and the court below, I believe, got it wrong, that they should never have dismissed the general negligence or 200 under the hazardous condition claims versus either defendant. They left the GC in as far as their supervision of the work, because yes, they were the ones who were supposed to inspect. There was nothing about the inspecting. It was taped incorrectly. There was a comment made during my adversary's argument about the tape. Plaintiff testified that there was no tape there. She said all the other areas of it were taped. This one area was not taped.
Thank you. I think we have your argument.
Thank you very much, Your Honors.
May it please the court, Britton Sparkman on behalf of respondent, third-party defendant, Collins Building Services, Inc. Our client, or we moved for summary judgment on all the third-party claims below. However, the court never reached them, dismissing the Hudson case.
Well, what do you think we should do?
Ruled according to us, as we put in our brief, Your Honor, affirm the court's dismissal as to Hudson and then keep my client out of the case. I'm happy to address any questions that the court may have with respect to the other items that we briefed. Otherwise, I'll rest on my papers.
Thank you.
Thank you, Your Honor.
Addressing the labor law 200 claim, as Justice Gonzalez correctly pointed out in the Jock case decided by the Court of Appeals, it held that 200 does apply in a non-labor law context. I would, however, point out that just a year prior, the Court of Appeals said that 200 does not apply in the non-labor law context, and this court more recently in 1998 in the Agley case also was more in line with Gibson than with Jock. But that's really...
But it's not academic. I mean, really, the 200 claim is just a codification
Correct.
Of common law. So
it's the same thing.
Yeah, exactly. We're talking semantics, really.
Right. I agree. With respect to the common law negligence claim, our client testified that at the end of every single day, which for MBI ended around 3 p.m., the client would walk around the premises, inspect the masonite. If there was any issue with it, it would be corrected.
Counsel, were any inspection logs submitted? Are they part of the record?
There was no...
Do we know, if I may, do we know when the hallway was last inspected?
Well, it was last inspected at the end of the workday for MBI, but you're correct that there was no logs created saying that this specific employee at MBI inspected the work. I believe one of the EBT witnesses was one of those people who said that he did have a practice of going around every day, inspecting the work, including the masonite. If there was a problem, he would fix it. Plaintiff comes by at 5 o'clock, 2 hours later, around 7 p.m., she trips and falls. With regard to the masking tape, there's plenty of photographs in this case. Plaintiff never identified in any of those photographs where she fell. There's a photograph of white tape on masonite boards, and the white tape, which if we want to presume is masking tape, is perfectly intact.
I don't think there's any presumption. I think that was the testimony of Mr. Bazile or the other gentleman? I mean, his testimony.
Well,
I understand you're saying that the plaintiff didn't talk about it, didn't testify about it, or testify that that's where she fell, but it was his testimony.
and she also testified that the security guards repaired the boards with tape afterwards. So perhaps that photograph
Well,
of
we
what
don't
is
have to
masking.
perhaps, because that's what he said. I'm not, that's what he said. That's what's in his deposition testimony.
I think he said that masking tape was used, but he didn't say
Blackall,
specifically
Mr.
where.
Blackall, the project manager.
Right, but I don't think he was specifically talking about the place where plaintiff fell because nobody knows where.
I agree with you. Okay.
Thank you, Your Honors.
It was the quality of the overall condition of the floor, which is what he was talking about. Thank you.
Very good, thank you.
Turning the page, Your Honors, to our contractual claims as against specifically Collins in this case. There's a broad indemnity provision in which Collins agrees to indemnify us for work arising out of the contract there. It is a broad indemnity clause. It is a clause not related to a construction agreement. So, as we all know, at common law, it can be indemnified.
What's your relationship with Collins?
Collins is our contractor through an assignment we obtained.
And did you establish that assignment?
Yeah, I believe that we did, Your Honor. It is in the record. I forget the page, but the assignment's actually in the record. I don't think there's a dispute as to the assignment. At least I didn't see one. So if this court decides that we should be back in this case, we're entitled to summary judgment on our contractual indemnity claim as against Collins.
Thank you.
Thank you.
I think that's everyone. Thank you. Did I give you time? Okay, all right. Okay, you don't have to make it quick. You have your full 2 minutes.
Your Honors, on the 200 with the means and methods, as you pointed out, there is conflicting testimony about what the proper way was to secure the masonite boards. And that's why the testimony was relevant there, that we have 3 different witnesses from the GC saying 3 different things. We have 2 of them which say duct tape is the only way to go, and then we have somebody else who turns around and says, who actually was the owner, who says, oh, you could use masking tape also. That's why Mr. Basile's testimony is so relevant here, because he's recognizing that there was masking tape there. So to the extent that the defendants are trying to reverse the decision below where they held in the GC on the 200 under means and methods, we're asking that that portion of it be affirmed with regard to the court's failure to allow the 200 claim to stand against both defendants on the hazardous condition. We're asking that that be reversed. And with regard to the 241-6 claim, we believe because the condition of the masonite was not in the condition that it needed to be used, there is a question of fact, and therefore the 241-6 case should have survived and be sent to a jury for determination.
Thank you.
Thank you.
Thank you all. Honeydew Investing versus J.P. Morgan Chase.
Good afternoon, Your Honors. May it please the Court, Eric Medina on behalf of the appellant Honeydew. Your Honors, the appellant Honeydew in this case is a victim of a fraud committed by the judgment debtors and brought a special proceeding to recover on the $4.6 million that had been chasing since 2017. It sought the appointment of a plenary receiver to marshal, amongst other assets, an apartment in New York.
I have to, how can your unsecured judgment have priority over Chase's perfected security interest?
So, Your
where,
Hon-
yeah.
Your Honor, Honeydew contends that the interest that Chase asserts is a secured interest was never perfected. What we've pointed to is UCC 9203, and we've also pointed to UCC 1201. In order to obtain a security...
Didn't FSBC and Chase file these secured interests long before your client came into the picture?
They did, Your Honor. We don't dispute with respect to this case that the UCC was actually filed. And in fact, Your Honor, the UCC was filed in August of 2000, and the promissory note wasn't signed until October of 2000, 3 months later. But what we contend is, Your Honor, that no security interest can attach because the debtors did not have the power in the collateral, and there's not been proof that the actual value was given in connection with the creation of that alleged security interest. So, Your Honor, the prime contention that the appellants raised on appeal is that with regard to the proceeding...
Wait a second. Below, did you raise that argument?
I'm sorry, Your Honor.
The argument that there wasn't adequate, that there was no consideration?
We did, Your Honor.
How did you raise it?
Your Honor, we raised in the briefing, we pointed out that...
No, I mean, no. What are your facts to support that argument?
I apologize, Your Honor. Exhibit M, they've asserted that the loan was funded. Their Exhibit M, which is...
Normally, one would not have to prove that unless you raised an issue of fact by a factual statement backed up by a document or something that would controvert that, right? So what did you put in?
Your Honor, we established there's a banking relationship between...
I'm asking you, what document did you put in that would controvert what the documents, what this UCC1 and everything else that was filed said?
Your Honor, we didn't have an opportunity to...
You didn't have anything, right? You didn't put in a single document. You sort of just said, I think it didn't exist without... What was your factual basis for that?
Your Honor, it wasn't our burden of proof. The factual basis was that it was a co-op.
We have a document that says, for consideration received, right, I'm going to give you a loan. And in fact, your client acknowledged in the settlement agreement that your loan, your debt was inferior to Chase's UCC1s, correct? The settlement agreement says that.
Your Honor, I don't want to say we acknowledged it because that
I
was...
will read you what it says.
Your Honor, I'm familiar with the language, but...
Right. We are free and clear of all liens other than those set forth in Schedule B, which lists Chase's UCC1. So you knew about Chase's UCC1 when you loaned the money, correct?
Your Honor, so the appellant in this case didn't loan money. The appellant was a...
I'm sorry, we gave the money to invest.
Right, they were defrauded,
right,
Your Honor.
Misspoke, okay.
But in this...
I don't think that's relevant to what I'm trying to say here. You knew about the UCC1.
Your Honor, we were told about it in that settlement agreement, and there was never any proof that was given, and many of the things in that settlement agreement, Your Honor, never bore out. In fact, there were numerous contempt proceedings that were brought because of this.
But normally one would not have to prove that. We take the document for what it says unless someone raises a factual issue, not an argument in a brief, but puts in a testimony or a statement or a document that might controvert it. So again, I go back to you. What do you have in terms of someone's statement or a document that would controvert what's in the official UCC1s and the loan documents and everything else?
Right. So, Your Honor, we have the absence of what we contend is an enforceable note. We have...
So in other words, the DBAs,
they
were making payments, I think, until July of 2020 on a note that doesn't exist?
No, Your Honor.
Doesn't exist?
Your Honor, we don't know whether or not the note exists.
But as my colleague says, then you have to assert something factually for them to respond to.
And, Your Honor, if I may just briefly for a moment, we asserted that this was a, quote, a negative pledge loan. It was in our briefing below. This was argued extensively before the court. This cooperative did not allow the creation of security interests in order to borrow or hypothecate against the shares
So
of
you step into
proprietary
the
lease.
shoes of now the co-op to say that, well, because maybe what was done wasn't effective against the co-op, but it's effective against the entire, all other unsecured creditors get the benefit of that too?
No, Your Honor. What we're saying is that the borrower, in this case, the alleged borrower, the Abadis, didn't have the power to hypothecate those shares in that lease. Because they didn't have the power to hypothecate the shares in that lease, and because the loan documents themselves contend that there's
Any
other
dispute there's a
collateral accounts.
proprietary lease? Is there a dispute that there's a proprietary lease here? And that they're occupying the premises pursuant to proprietary lease? Doesn't that mean that they did have the shares to be able to transfer, to have the right to live there?
Your Honor, I see that the...
You can answer the question.
Your Honor, we don't dispute that there are shares, and we don't dispute that there's a lease. We dispute that the documents of the cooperative did not give them the ability to hypothecate either one of those in order to receive a loan.
So what did the co-op do after that happened? Nothing.
Your Honor, at the time that it allegedly happened, the president of the co-op was the judgment debtor, Mr. Abadi. So we allege, Your Honor, as we have for a very long time in this case, with regards to the actual loan documents, and importantly, it's with regards to the burden of proof, Your Honor, as to priority, we can only prove what we have. This appellant didn't have an opportunity to conduct a trial with regards to adverse claims regarding the turnover in connection with this, with this special proceeding.
Thank you. Thank you.
Thank you, Your Honor.
May it please the Court, Erica Goldman for Respondent JP Morgan Chase. As Your Honors have picked up on, there is a lot of rhetoric and hyperbole and distraction and irrelevant facts that were raised on appeal, many of them for the first time. But that's all a distraction from what the central issue here is, which is to determine whether the Supreme Court erred when it held that U.S. Bank did have a prior perfected lien.
How did you establish value given under the UCC?
We have a promissory note that is signed by two parties. We have a party who, as you noted, made payments for 19 years pursuant to that agreement. We put in as an exhibit to our affidavit a copy of the payment history, which documents in real time, and the affidavit details, explains why that is a business record and why that can establish that payments were made over a period of time until the date of default. My client commenced a non-judicial foreclosure because that is the proceeding for when you have UCC interests at issue. And Honeydew commenced this special proceeding to block that. That proceeding was commenced in the beginning of COVID, and so it was held in abeyance, and then the property was sold through the lower court.
So, counsel, let me ask you, the language in the proprietary lease which requires, assuming that that wasn't followed, does that mean that the assignment is void, or what is the consequence of that not being followed?
Sure. Well, as the lower court held and as we've maintained as a non-party to that contract, Honeydew has no rights here to step into the shoes of anyone or to try to assert that as against my client.
But I mean, if it's void, if then it means as a matter of fact that it was void, it wouldn't matter who, it's void as to everybody in the world. So why is what is the consequence of that?
Sure, it actually doesn't impact. It is irrelevant to enforcement under the UCC, which is a three-part test, and it's laid out in the brief. So for a lien to be valid and enforceable is whether the debtor signed documents describing the collateral, whether it attached, and then whether that interest was perfected. The argument here has been on the second prong of that, which is whether it attached, and that's under 9203, the UCC, and that's whether A, value is given, B, whether the debtor has rights in the collateral or the power to transfer.
Right, okay, so we all agree, So do you think, do you agree with me at most it would give rise to the co-op having a claim?
Correct, that the co-op did not pursue here, and in fact, the co-op reached out to Chase after this proceeding was, right around the time the proceeding was commenced, to in fact ask Chase to make a payment of back due co-op fees of over $120,000, which ultimately were added to the escrow here that Chase advanced. And so we didn't make the argument that there was any constructive agreement there, but clearly named here as a respondent was the co-op who at no time asserted any rights as to the Abadis, and in fact approved of the sale to the third party And I delivered the original stock certificate and original lease to the co-op in order to have it reviewed, confirmed as original, canceled, and to facilitate the sale.
And let me just ask you one last question. Did you see any documents or testimony or sworn statements from anyone that would contest the consideration for the loan?
Did not. And at all times, the Abadis actually affirmed, not only in the settlement agreement, in the judgment debtor action, but here in this proceeding, affirmed that we had a first lien, affirmed that payoff amount, actually submitted on 3 separate occasions a proposed distribution, and under that distribution, having JP Morgan as servicer for US Bank be satisfied first from the proceeds of any sale. If there are no further questions.
Thank you.
Thank you.
Good afternoon. Alex Patchen from Liston Abramson on behalf of respondents Carlos and Barbara Abate.
Did you ask for 2 minutes?
Yes.
Yes, okay.
Again, we agree with Chase as to the priority issue. The only issue here is whether the issue of the application of the homestead exemption. The property was exempt from attachment for support of a money judgment. That was waived below. The judge, Justice Bannon, made clear that Honeydew neither objected nor responded on that point. There was full briefing on it. I'm happy to go into why it was appropriate to grant the Honeydew the homestead exemption and to authorize it, but
I just want to ask you, do you deny that you got the money from the loan?
No, absolutely not.
Is there any question that the loan had adequate, the note had adequate consideration?
No, we believe it was adequate. It was being paid through numerous years until they went into default.
Thanks.
And did the co-op ever move to void the assignment?
No, Your Honor.
Thank you.
Thank you, Your Honors. If I can just address briefly what was some of the questions that were raised earlier. With regards to the primary evidence, with regards to whether or not the note was actually funded, there's a partial payment history. There's no history that shows origination. There's a relationship with a bank and a very sophisticated set of judgment debtors. We're not talking about filling in the gaps with information that the Abadis at every step were able to confirm on behalf of Chase. What we're talking about is whether or not they actually received value when they made the loan. If they had other accounts at Chase, which the evidence established that they did have other accounts at Chase, we don't know who funded the initial loan. We don't know what the $1.2 million loan in 2000 ever came from.
But I mean, that is just not right. We do know. We have a note that says it, that is notarized, and so if you are challenging that documentary evidence, you can't just say, I don't know if this is true. That's what I've been asking you more than one time. It's not enough just to say, I don't think this document is true. You have to have some fact basis for that, which would call it into question. And that's why I asked the Abadi's lawyer directly, did you get the money? Right. So I don't know why you keep pressing this.
I understand Your Honor's concerns and
No, I mean, it's not my concern. It's just what the law is.
Well, Your Honor, but there's no proof that there's an enforceable claim here.
There's a note. What do you have to controvert the note?
Your Honor, the note itself in a foreclosure proceeding wouldn't stand up.
Is this a foreclosure proceeding?
It's not a foreclosure proceeding, Your Honor. And that's the point that
the underlying tenor of your argument essentially is that standing and all that stuff's not been established, and you're really conflating two different bodies of law. And I would submit to you that this case is governed by the UCC and only the UCC.
And Your Honor, I agree with you, and that's in fact what the Shore case points out, that these kinds of cases should be covered by the UCC. But the conclusion in the Shore case was based also on the New York banking laws, which is something that was set forth in our reply to the opposition that was submitted by the respondents. And that specifically says that you can't give a partial assignment because at the end of the day, a UCC lender wants to be able to conduct a sale on the courthouse steps. You can't give a partial assignment. So if there is no security interest that the co-op permits to be created, there's no manner by which the bank, the UCC lender, so-called lender, could possibly effect a transfer of title as a result of a UCC sale.
Thank you.
Thank you, Your
Thank
Honor.
you both. Wait, I'm sorry. Oh, you have 1 minute, yes.
Just want to state quickly that all of the discussion here today on whether value was received actually was raised for the first time on appeal, and I'm not sure why that has taken sort of the focal point of the conversation, because what really comprised the bulk of the record below is this argument about whether, as a holder of a note that's unendorsed, you can enforce it, and I think we did explain in great detail, and the Supreme Court agreed with us that even if we had to examine standing in a foreclosure context, that we proved that, but we're in the UCC realm, and so we don't have to have a note that is enforced in blank. There are other relationships you can have to a promissory note that allow you to enforce it, but again, enforcement is controlled by the UCC, and that very simple three-step process that we talked about earlier today, and under that process, it's indisputable that we had a prior perfected lien interest here.
Thank you.
Thanks.
Thank you all. MLRN LLC versus US Bank.
Good afternoon, Your Honors, and may it please the Court. Michael Marcucci for U.S. Bank. There's a lot here, so I'll jump in and start with our appellate issues on the statute of limitations on the repurchase claims with respect to 57 certificates. Here, the trial court made two basic errors that require reversal. First of all, the claims that MLRN is bringing here did not accrue to the RMBS trusts. They accrued to prior holders of the trusts. And as to HBK Master Fund, which we know was the prior holder as to these certificates, the trial court is wrong that HBK Master Fund had no principal place of business. The record was undisputed that HBK Master Fund, which is a Cayman Islands entity, there's no evidence of any actual business people for HBK Master Fund doing anything in the Cayman Islands, and the vast majority of the business work being done for HBK Master Fund is done in Texas.
And in fact, didn't plaintiffs stipulate to that?
Yes, Your Honor, they stipulated to that. It's in their SEC filings, and in other cases where this—
To me, the stipulation is really all we need.
Yes, Your Honor, and under that calculus of 4-year Texas statute of limitations, which would apply to those certificates, those claims are untimely. Second issue with respect to standing. On standing, MLRN was the movant and moved for summary judgment. MLRN is an entity that was created in 2018 and funded with the certificates that formed the basis of this lawsuit. As far as we know, this lawsuit is the only business that MLRN has ever conducted, and they have not been able to establish that the claims they are bringing transferred in the chain of custody for all 122 certificates. And we would submit that they have read to the trial court, and MLRN on appeal reads too much into this court's decision in Royal Park v. Morgan Stanley, that does not require that New York law reach back and apply the rule of general obligations law 13107 to every transfer along the way.
So what law applies with respect to the issue of standing? Go ahead, tell me.
So the law, it depends on which transfer we're talking about. So, and which claim we're talking about, because this portfolio, this litigation portfolio, came from a lot of different sources. And they have not told us exactly which date each one of their claims allegedly accrued. So for whatever claims go to trial, MLRN has to establish that they actually own the claim they're suing on. None of them, as far as we know, arose while MLRN was the holder. So they have to establish the ownership of those claims throughout.
There was no evidence of the upstream transfers of assignments of the right to sue, correct?
So there are some. So we know, for example, as to some of the CDOs, where an HBK affiliate was the collateral manager of the CDO, The HBK affiliate directed the transfer of certificates from the CDO to HBK Master Fund, which then found their way to MLRN. And so we know the provenance of some of them, but not all of them. We don't know exactly where everyone was. We don't know where these contracts were entered into because it was.
If we were to find that New York law applied, for example, with respect to the, well, to sets of these claims, wouldn't that obviate the issue of standing?
Well, if New York, if 13107 applies to every transfer just because the case is filed in New York?
Well, that's the question.
Right.
So the answer, if that's the issue, sure. I mean, if 13107 reaches back to transfers in 2009 between entities in California and Texas to govern those transfers, yes, that would solve their standing question. We don't think we can read Royal Park v. Morgan Stanley that expansively, that you take C-Link together with Royal Park. It doesn't apply New York 13107 universally just because they sue here, because if they sued in Texas, you'd have a different law that would apply.
Could that be an issue of fact?
We think it is, right? We think it's their burden to prove that we didn't move for summary judgment on standing. MLRN did. So it's their burden to prove that with this litigation portfolio they assembled, that they actually have the claims that they're suing on, right? And we don't think they established that at summary judgment, and we don't think a U.S. bank is stopped from making this argument because it involves applying different law and applying different facts. And so we just think this is a question of fact, and MLRN has to prove at trial that it actually owns these claims, and the jury will believe it or not, but they haven't established it as a matter of law. And the same is true with respect to two of our other issues. One, what I call the Commerce Bank EODs. So there's 5 trusts for which the trial court granted summary judgment, in large part on the basis of Judge Pauly's denial of summary judgment in the Commerce Bank case. And the evidence that was submitted here and in Commerce Bank is evidence that both this court in Western and Southern and IKB concluded was insufficient to establish events of default, and evidence that the trial court itself, as to all of the other trusts, concluded was not competent evidence and denied summary judgment. And so you can't transform a denial of summary judgment in one case when Commerce Bank never bore the burden of establishing the absence of a material fact and turn it into summary judgment here, right? It's not a decision.
And you know, I love Judge Pauly, but we're not bound by that decision in any event, correct?
That's correct, Justice Scarpool.
We can make, he was a great guy, I liked him a lot, but we're not bound by his decision.
He was a lovely man, absolutely. I disagree with some of his decisions, but I think he was a great man. And then it also relates finally to our Champerty affirmative defense. I mean, Champerty comes up a lot in these cases, in these litigation portfolio cases, and we have what is a pretty typical factual record on Champerty here. And it's a similar factual record that the Court of Appeals found insufficient in Justinian. It's a similar factual record that the Court of Appeals found insufficient in Bluebird. And that is, we have what U.S. Bank offers, which we would say objective.
So then, I just want to ask you, were these, when they were purchased, were they zeroed down?
Almost all of them were, Your Honor, yes.
Were totally zeroed down?
Totally zeroed down.
There's an argument that there was no legitimate expectation of regular payment through the ordinary course.
Correct, Your Honor. Outside
so the only reason why you would buy them is to litigate on them.
To litigate on them, or, I mean, they did testify they thought there could be another litigation that would result in money or a government settlement. And so there's this factual question about intent. And we offer objective evidence, the timing of the purchases, including some that were purchased after the complaint was filed in this case, and then added to the amended complaint, which I think pretty much.
When was the last time any of the certificates had paid out?
I don't know the answer to that, Your Honor. It was sometime before, the big bulk of them originally were acquired around 2012, and many of them had been zero for a long time, but I don't know the last payment on each one of them.
Right, so I mean, maybe if it was zeroed out 3 months ago, it might be a different, but we just don't know.
We don't know the exact payment history of each of them. We know they paid almost nothing for them. They viewed it as sort of almost like an option or a lottery ticket, see what's going to happen, and then it turns into this lawsuit. So I think where you have that objective evidence from which a jury could infer an intent to acquire these things, you can't overcome that with what they have, which is testimony from their managers at HBK saying, well, we had all these other reasons to do it.
Ultimately, that's credibility, right?
It's a credibility question, Your Honor. We didn't move for summary judgment on this. plaintiffs did, and we submit that should go to the jury. So unless there are further questions, I'll see you on rebuttal.
Thank you.
Thank you. May it please the court. Timothy DeLang with Wolmuth, Marr, and Deutsch on behalf of MLRN, the respondent, and cross appellant. There are several issues. I know there are questions from your honors. I'm going to take them in the order that Mr. Marcucci addressed them. And the first I want to address is the statute of limitations. And counsel for U.S. Bank completely ignored Justice Borach's decision underneath, which found that these are New York trusts and the claims accrued in New York. That is unquestionably where the first injury was felt. These are trusts that hold these mortgage-backed securities.
Go ahead.
You know, I think your argument would resonate more with me, I don't know the rest of the bench, is if you brought this lawsuit in a representative capacity. But you're essentially, you're bringing it in the shoes of the certificate holders. And I think a good argument could be made that the place of injury is where the certificate holders didn't get what, they were underpaid. That would be the place of injury. How do you respond to that?
My response is you have to ignore where the injury is first felt. These
You have to, I'm sorry, what? You have to?
You have to ignore where it's first felt.
Why?
The certificate holders, because they are not, they are entitled to the distributions from the corpus of the trust. The trust has to be injured first, and then it flows through the waterfall to the certificate holders.
Except that your complaint doesn't allege that at all. Your complaint alleges injuries to the certificate holders, not to the trust. So it seems to me that the position you're taking now is completely contrary to what you seek in your complaint.
It is, my complaint definitely seeks the damages that flowed through to the certificate holder.
No, it seeks the damages fall.
Yeah, I think he's agreeing, right? So there's nothing, so your complaint doesn't have, we're not going back to the trust. The complaint is you bought certificates. You don't represent the whole trust. You're not talking about trust damages. You're talking about the damages to the certificate holders to whom you bought. So the only way we could look at damages in that instance is to the certificate holders. We can't ignore that. We're not going back to the trust.
I totally agree on the damage point, and I do not dispute that. The standard in the law is where did the injury accrue, to whom, and to where.
Okay,
and we
so let's start about that. Where did the injury occur to the certificate holders?
I would argue and submit the injury was first felt.
We're not talking that.
That would be the trust, wouldn't it? Not the certificate holders?
Correct, and then that injury flows
that's
through
the question
to the
here, but you keep going back to the trust, even though you keep saying that, well, yeah, the certificate holders felt it, but those are two separate things, and the law is different if we say it was felt first to the trust versus the certificate holders. So that's the issue, and the question is, are you saying that it was felt first by the certificate holders, or are you saying that it was felt first by the trust, even though the certificate holders are the ones who would have, it seems to me, they were the ones that felt the loss.
At the end of the transactions, yes, the certificate holders feel the loss. It is first felt to the trust, and then 30 days later, or when distributions come out, then it flows through to the certificate holders. That is the fact pattern, that's how it works.
So and you don't represent the trust. It's like me saying I want the situs of injury to be where my co-defendant that I don't represent, or the non-party who's not even a party to the litigation. So you can imagine how that doesn't resonate. Let's assume that we all agree that it's a place of the injury, and it's the injury where the certificate holders were injured, where they didn't get their money, right? So that is not New York. Correct?
I'm going to answer that, and I just want to back up and just point out the Court of Appeals decision in Deutsche Bank v. Barclays.
No, answer the question.
Which does not foreclose.
I just don't want to, yes.
Right,
Yes, we all know the RMBS cases in this area, so let me just ask you again. If we assume that the injury is to the certificate holders, the people you actually represent, or your third-party purchasers, that is not New York. Am I correct on that?
The residence of those plaintiff certificate holders is not New York.
So then we would have to figure out where those certificate holders were to see where the situs of the injury was, and then we would apply that law, right? In that kind of, in this kind of case.
Your summary of that analysis is correct, I agree. And so moving on from New York, I wanted to point out just the general rule is that the accrual is usually the place of residence of the plaintiff. The Court of Appeal basically left open the possibility there could be situations where it's not. Moving past that,
Yes.
here the argument is it the Cayman Islands or not? We assert if New York does not apply, then the residence of the plaintiff, here it's HBK Master Fund, which is a limited liability partnership organized under the laws of the Cayman Islands. It has no employees. It has
You
no...
stipulated in the joint statement of undisputed fact that its principal place of business was in Texas, in the record before us. How can you say something different now?
There's a slight distinction I want to point out. It was a principal business office.
Right,
It
you're right, it's a slight difference, which is really semantic. If it's their principal business office, I read that as their principal place of business, and I don't see how you can now say their principal place of business is that they don't have one or that it's in the Cayman Islands. You're stuck with what you stipulated to.
If you go back...
Aren't you? I mean, I don't see any way you cannot be stuck with what you stipulated to.
The stipulation stipulates to that fact with a citation to the SEC filing. And the SEC filing lists the principal business office of multiple HBK entities, including the HBK Master Fund.
Right, and that's what you're concerned with.
Correct. And every entity has the principal business office listed as the Dallas address. For HBK Master Fund, it says care of that office, because these are how these funds work. They don't have employees. They don't have physical presence. They are run through the investment advisor.
If for the purpose of the SEC, they stipulated that their principal place of business was Texas, why isn't that dispositive?
I don't believe it is. I think it's a question of fact based on the evidence, the fact that it was an SEC filing that said care of compared to others that listed the address without the care of, and then the uncontroverted testimony that it has no physical presence, it has no employees, the testimony they can't put anything else. That's the one piece of evidence they have, and that is it.
So if we agree with you, if we disagree and find that it's the certificate holders and not the trust, the people who are the actual plaintiffs here, not the trust, which is not, you're saying to us we need to send it back to the trial court to make a finding, a factual finding as to where the certificate holders felt their injury.
Well, I believe U.S. Bank agrees that in the footnote, Justice Bork did find that it was Cayman. And so I would submit that then that would
Okay, I'll ask. But
then that would be affirmative. At least that's what
I
they
thought you were
argued.
just arguing we should send it back as a fact issue, but okay.
Well, what I'm saying is if you're inclined to disagree with that, at a minimum, it'd be a fact issue based on the evidence that has been submitted.
Okay, you were asked a lot of questions, so you didn't get to your standing issue and anything else. I'll give you some more time.
And I'll try to be real quick on standing. First is standing is procedural. It's Royal Park, the decision from the First Department. Justice Bork found that. That would be New York law.
Right, but if we find instead that it's not procedural, but it depends on whether or not you have the right to sue, it seems to me that in order for you to have the right to sue, you have to show that that right to sue was transferred all along the line. And I don't, that may have been shown as to the most recent transfer to you, but I don't see that there's any evidence that it was transferred all along the line upstream. So doesn't that affect your standing?
No, I don't believe it does because New York law applies. Whether you apply...
Excuse me, I was asking you to assume that New York law doesn't apply because it's not procedural, because it's a question of your right to sue. So assuming that we think it's the right to sue, which is more than a procedural right, why don't we have to have evidence of all of the rights to sue being transferred all along the line?
Because I think inherent in your question is you jump from it's not procedural to automatically New York doesn't apply.
No, I'm asking you to assume that.
Right, my point that I want to make clear is if you say it's not procedural and we're going to look to what substantive law applies, then we argue New York substance applies. Your question builds in, okay, now substance it doesn't apply. So if you hold that substantively New York doesn't apply, then yes, you would need the transactions throughout. We believe that substantively, even if you decide it's not procedural, New York law applies.
Where was the place of contracting?
We assert that the place of contracting was in New York
And how is that?
through the DTC and the contracts of the PSAs. And this is the exact same arguments that U.S. Bank made to the federal court when they obtained an affirmative ruling in their favor that New York law applied to all of these transactions.
And what was that, in Commerce Bank, I did read it a couple times. Wasn't the court applying Ohio's choice of law there?
They were, yes.
So isn't it factually, at least, the law is different, or are they the same?
The law is not different. The factors are the same. They still primarily look to the place of contracting and the place of performance. And the court found there, based on the arguments that U.S. Bank made to that court successfully, that it was the DTC. That's where the PSAs determine the place of contracting, the place of performance, where ownership is transferred. The court accepted that and applied it. And I note in this particular case, Justice Borak, not only did he find they were judicially estopped from arguing anything different, he then found, in any event, if I applied choice of law, it would be New York.
Is it undisputed here that DTC was involved here?
Undisputed that it was involved, yes.
Yes. Was that the clearinghouse? DTC?
Yes. DTC, yes.
Okay.
Thank you.
Thank you for the extra time, Your Honor.
I'll start, Justice Scarpullo, with your question about the location of the certificate holders. Justice Borak did find that the place of incorporation was the Cayman Islands, but he was just wrong about the law. Where you have a principal place of business, the accrual of the claim is at the principal place of business. And the cases that look to state of incorporation, or in that case, island of incorporation or country of incorporation, is where you don't have evidence of principal place of business. Here it is stipulated. As to your question about DTC, Your Honor, the record's a little bit different in the two cases. Commerce Bank itself was a DTC participant. They had a subsidiary that was a DTC participant, which means that if it's going to be sold from Commerce Bank to another DTC participant, it goes through DTC. On the record that's here, and again, this was their motion, we know the DTC participants, or what they alleged the participants were, I think it was State Street and Bank of New York, with whom HBK transacted. We don't know if those transactions actually went out and transacted through DTC in the record. There's an affidavit from someone at HBK saying they did, but we don't know whether or not, for example, when you go out to the participant, if they have somebody else who's selling it.
This is a motion for summary judgment, right?
Excuse me?
This was a motion for summary judgment?
By MLRN, yes.
Right. So was a note of issue filed?
No, I don't believe so.
Oh, okay. So there's more discovery coming just in case. Okay. Because I didn't understand that. I was like, on summary judgment, you should know one way or the other, but this is a pre-note of issue summary judgment motion.
Yes,
okay.
Your Honor.
All right. And you're saying you don't think that the DTC was the situs?
We don't know. We just don't know if the transaction actually went through DTC, or if when HBK called up to buy the certificates, the participant already had them on the books and just moved them from.
Did you dispute that below? I don't recall.
We did. We
did.
you know, and again, okay. we did dispute it, and it's, you know, I think we just don't know the answer to that on their burden.
So you're saying, even with that, that's an issue of fact, essentially?
That would be an issue of.
They didn't make out a prima facie on that.
That would be an issue of fact, and then obviously Commerce Bank applied a different law in their different certificates, right? And Ohio emphasizes place of performance, New York place of contracting. I did just want to address briefly the cross appeal. Mr. DeLange will probably get to it on reply. And I think that the position that MLRN is taking on appeal here runs afoul of one of the basic principles that the Court of Appeals has applied to these RMBS cases, which is that we don't treat them differently. We're going to apply the regular rules of contract interpretation, the regular rules of accrual. And even though I recognize the court's opinion in IKB said that the approach that Justice Friedman and Justice Borak took was not correct, on this record, we think summary judgment can still be granted as to reasonable time, the reasonable time to enforce whatever enforcement means. I mean, we have a protocol for the addressing of document defects.
But how do we make that determination? I mean, that's the frustration I have in general with these kinds of sort of loosey-goosey provisions in these agreements. How do we make that decision as a matter of law, sitting here saying what a reasonable time is?
So I think if you take the contract to begin with, you have a process where there is a certification at closing, 90 days later, there's an interim certification, 90 days later, there's a final certification, then the party has 90 days to cure. And our view is that the outer limit of a reasonable time to enforce would just be another 90 days. MLRN's position is that it's 1,800 days. And they have not cited any cases where a court found that a reasonable time to perform a contractual duty was 5.5 years. And what they're really positing here is something that doesn't exist under New York law, which is they posit that we had a duty to enforce, we didn't enforce, but there was no breach. And there was no breach until the last possible day a lawsuit could have been filed. And that's clearly not the law. There's clearly no basis in New York law for that kind of 6+6 analysis. Now, maybe there's a question of fact, is it 90, is it 120 days? But their position here is that the exception reports themselves identify material document defects that should support repurchase, and those exception reports themselves would form the basis of a lawsuit. And even if it is, even if enforcement requires a lawsuit, 90 days is more than enough time to file one. Thank you.
Thank you.
Thank you, and I'll be very brief on the cross appeal. First point I want to make is I believe counsel admitted that the intervening controlling law from this court in IKB requires reversal of what Justice Borak did below, which he relied on the IKB Supreme Court decision. It was reversed. I think it requires reversal. They've now pivoted and tried to establish that they somehow have proven as a matter of law what a reasonable time is. They have not. And you need to look no further.
Do you contend a reasonable time is 5.5 years, as counsel claims?
I contend that the breach did not occur until they allowed their enforcement rights to lapse.
Okay, what are you contending a reasonable, are you contending that a reasonable time is 5.5 years, as counsel argues?
No, I'm contending that they have not met their burden on summary judgment to prove as a matter of law.
As a factual matter, if we were to agree with your position, how many years later would this have occurred? Is it 5.5 years?
In
this case?
If you agree with my position of what I believe the rule should be, it should be when they allowed their enforcement rights to lapse. And you can look at the cases and their own conduct. They wait until the very last minute to file these claims. They've done it. We've submitted examples, and it's in the record. There's two cases, Bacall and Walnut Place, where certificate holders actually asked the trustee to do something, and the trustee said, this is all premature. We still have the rights to do that. And these are the exact pieces of information that were relied upon by Judge Engelmeyer. I know it's not controlling, but it is persuasive, which was the first opinion that came out after this court's opinion in IKB. US Bank tried to make the exact same arguments there, and they were rejected.
Thank you. Thank you both.
Thank you.
Oh, my God. People versus Aaron Carson.
Me too. Peter and I'll tell you that in the fall, we had the same issue. Given to both of us on IKB, on this stuff.
I'm sorry, you may be.
No, not at all. Thank you. May it please the court. Ben Schatz, Center for Appellate Litigation for Mr. Carson. I'm asking the court for a modest sentence reduction of 1 year in Mr. Carson's attempted murder case. This is undisputedly a horrific crime. You will not hear from me any suggestion that this crime was not horrible from start to finish. It is a negotiated plea. I understand that. I'm asking for this slight sentence reduction in light of Mr. Carson's sincere expression of remorse at both plea and sentencing, which was quite unusual in a case like this. You don't often see that kind of expression of remorse and that kind of dialogue with through the DA with the victim's family, which is an apology and an acceptance of apology. And you certainly don't see that.
So, counsel, was there an appeal waiver here?
I'll address the appeal waiver right now, sure. it's
Well,
not
finish
valid.
with your first issue and then go to the.
Sure, and, yeah, and I think the fact of remorse is really set off in quite high relief, given what we know about Mr. Carson's life, which is, it's hard to imagine someone dealt a worse lot in life, and I'd urge the court to look at the pre-pleading memorandum. It is described by the social worker as an abysmal hell, his childhood. He loses his mother, his father is absent, his foster family abuses him physically and emotionally. He's locked in a dark closet, he's deprived of food, he's eventually required to identify the body of a close relative when he's only 12, he's stabbed when he's 15. It's no surprise whatsoever that he becomes chemically dependent and ultimately justice involved, and the culmination of that is this case. But I think it's particularly impressive in light of that background that he gets up and says, "I'm sorry." I will address why you should reach this issue in response to Your Honor's question about the appeal waiver. The appeal waiver isn't close in this case. I think it's one of the worst on the record colloquies I've seen, because it comes after he's already pled guilty. You can't have a voluntary waiver when he's already admitted guilt to the crime. That's the definition of not voluntary. That's just one of the reasons. There are others we cite in our brief. There isn't the separate and distinct argument, separate and distinct language that you're supposed to see in these colloquies that this court has said is required, which is that the waiver of the right to appeal, it has to be clear to the defendant that it's separate and distinct from the other rights you're giving up on the plea. The court essentially says the exact opposite here. This is not a valid waiver. I'll just...
What did the defendant say when asked about this, about the written waiver? Did he say words to the effect that I'm knowledgeable about this stuff?
Yes, at the very end of the, after he's pled guilty, he says, "Oh, I'm familiar with all of that." But you know,
Is that something that we should take?
What do you say at that point, Your Honor? You've just bought a car, and the dealer tells you, "Oh, this can only go on 2 roads." By the way, I knew that the whole time. Like it says nothing about voluntariness. This is the very end of a long process, and he's finally pled guilty. There's no turning back at that point. It's just, as a matter of law, I think, not a voluntary waiver.
He did say, "I'm familiar with the form and I'm very knowledgeable." That doesn't count.
Do I wish he didn't say that? Yes, of course. Do I think it makes an otherwise invalid waiver valid? Not at all. This is not a this is just legally not a valid waiver because the colloquy is so deficient, both on the voluntariness prong and on the knowing and intelligent prong. There's a lot of confusing stuff that the court says during this colloquy. If the courts would just get up and read essentially what's on the written waiver orally, we'd have a lot better shot.
We sure would. I completely 100% agree with you there.
Thank you. I'll save time for rebuttal. Thanks.
Good afternoon, Your Honors. Michael Tarbutton for the people. As the waiver, Your Honors, the defendant knew exactly what he was doing when he waived his right to appeal. After all, as Your Honors have pointed out, he said, "I'm very familiar with those things," pointing to...
What counsel isn't... What about the fact that it came after he'd already pled?
Well, this had plainly been negotiated before the parties were on the record, before the plea proceeding. In fact, at the very beginning of the plea proceeding, the court mentioned that a waiver of appeal was required. He explained the effect of the waiver on the condition that the 2 different guilty pleas here were going to be independent. So if one was overturned on appeal, the other was still stand. He discussed that. The prosecutor mentioned the waiver of appeal. All this was well before he allocated the facts of the crime. And it was plain that all this had been negotiated beforehand, because when the court got to the waiver of appeal and he asked the defendant, have you reviewed this written waiver with your attorney? He said, "Yes, I have. I'm very familiar with it." There was no pause in the proceedings up until that point where he could have done it during the proceedings. He'd plainly gone over this waiver with his attorney beforehand. This wasn't a surprise to him. So he wasn't ambushed after he'd admitted his guilt with suddenly a plea waiver requirement. That's just not appeal waiver requirement. That's not what happened here. And again, the defendant, he is very knowledgeable on this. He's pled guilty 6 times before. This is his
Counsel, I have never seen, as much as I know case law says it, any defendant that is so knowledgeable that he can recite all of the legal issues and claims and respond, that are involved in this waiver. So he could, to the high heavens, he could claim, I am so familiar with this, I don't need to hear it. That wouldn't make it so. So why don't we just stick to the part that if he said, yes, I spoke with my attorney about it, okay, that's one thing. I understand it based on what I discussed with my attorney. The fact that he has been to court 6 times and pled 6 times, there are lawyers and judges who don't get the waiver right.
Sure.
So I don't think we should be now putting a greater burden on defendants to know the law in that way.
Sure, Your Honor. But as you pointed out, he did go over this written waiver with his attorney. And while the court didn't go through the entire waiver with the defendant, he did make clear that he still had the right to raise appellate claims, because he said in that written waiver, the residual rights you still have. And of course, the waiver is very comprehensive and detailed, and he said he went over it with counsel. So sure, it'd be nice if every judge read the whole waiver out, but he didn't need to, because we know that his counsel went over him and advised him about this before.
Well, does the judge state things that make it confusing and state anything inaccurate so that the waiver would still not cure it?
I don't believe so, Your Honor, because he does say things like, in this case, you're giving up your right to appeal. It will be on your permanent record. There'll be no review, except for those residual rights that are listed in that appeal waiver. So if you read everything the judge says, then it's not inaccurate. And again, the defendant has the written waiver before him, and he had the advice of counsel on it. So the waiver is sound. As to the excessive sentence claim, as to the merits of it, Your Honor, the defendant apologized for shooting the child, but he didn't apologize for manufacturing and selling crack from his apartment. He didn't apologize for the—
Did someone say at that point that's insincere because you're apologizing to that family, but you're not apologizing to selling crack? Or did anybody ask him if he was also apologizing for selling crack? I mean, when someone is standing, how old was this defendant?
I don't know, Your Honor. I don't recall.
Not old, pretty young, and has just pled guilty to the murder of someone who was not intended, and he turns around and says, I am sorry. I don't know that we should be parsing out that he was only sorry for that because he only said it. He was speaking to the family of the deceased, right? A kid on his skateboard or something.
Sure, that's fair enough, Your Honor.
Perhaps we shouldn't read any more or less into that.
Sure, that's fair, Your Honor. But he did have the opportunity, for example, in the pre-sentence report, to express regret about all of this, and he didn't. After all, he expressed sorrow for shooting the child, but he was trying to kill somebody. The man he tried to shoot escaped, but he was trying to kill somebody.
Absolutely, but what you were using was his apology in the courtroom.
Sure.
Yeah.
I'm just pointing out, Your Honors, that there are other crimes involved here that he did in a whole criminal lifestyle which he celebrated. On his cell phone, they recovered photographs of him with his guns. They recovered a homemade video of him rapping about shooting people. He has this terrible childhood, and I don't mean to minimize that at all, but he's done 3 stints of prison time in state prison. He's had many opportunities.
Be careful about taking evidence from something that someone raps about. That makes me very uncomfortable to suggest that that's evidence.
Sure, I suggest when he's rapping about shooting people, that is probative to the fact that he's embraced this lifestyle.
Well, I don't need to hear that he has rap videos or whatever, rap text to understand that he embraced a lifestyle.
Right.
He pled guilty to the crime.
Right.
He shot someone. So, I mean, that enough, he embraced the lifestyle.
Sure.
But his regret was sincere.
Certainly, Your Honor, for shooting the child, but...
And no one questioned him about whether he was sincere for the other and simply wasn't stating it.
No, Your Honor, but that makes that a little different from any other case where a defendant has a terrible record, has done terrible conduct, and was not reformed, was not even deterred by the prior prison sentences, where a lengthy prison sentence is necessary to protect people from other violent crimes from the defendant.
So we should ignore the fact that he apologized.
No, Your Honor, but you shouldn't give it any more weight than it's worth.
Well, it's worth what it is. He said it. Thank you.
Yes, Your Honor.
Just to be clear about the scope of the acceptance of responsibility and remorse, what he says on the record is with respect to the family and the child, but the pre-pleading memorandum makes very clear that he does not seek to minimize, condone, or excuse the allegations. He is eager to accept full responsibility for his actions. He is a 30-year-old man in his early 30s. He's going to be in prison until his late 30s. He is going to spend a decade more or less in prison for this. And what a one-year sentence reduction does here, it's not a significant amount of time, but what it does
So,
is...
Counsel, if I may.
Could I just, before you ask your question, could I,
exposure-
excuse me, could I just hear the end of your sentence?
Yeah,
first?
what it says is, you've done something horribly wrong, and you've accepted responsibility for it, and just as you have acknowledged that you have wronged society, we are acknowledging that in many, many ways, society has wronged you too, and we're not giving up on you. You're going to be there for a decade. You're going to suffer in prison for a decade, but you've got a long life ahead of you, and you've been kicked in the head every day of your life, and we hope that on the other side of this, something positive can come of that. And there are some indications of that in the record of his effort to be rehabilitated and to be productive.
Justice Gonzalez, you had a question.
Yes. So my understanding is that his exposure here was 25 years on one count and 12 on another, right?
Yes.
And the sentence was 11 and 3, and those were concurrent. So weren't the factors that you're bringing to our attention already considered? That's one. And two, to what extent is a 1-year reduction significant? Not to say by any stretch of the imagination or imply that incarceration isn't anything less than it is, but why I don't get the 1 year under the circumstances.
Well, so that you can just focus on the question, he just finished answering the question about the 1 year. So the red light is on. Why don't you address the first part of the question, which you didn't answer?
First question is, you're absolutely right, and we concede that it was a negotiated plea. That doesn't do anything to this court's broad interest of justice power to reduce sentences when it feels that they should be reduced.
Thank you. Thank you both.
Okay, thanks.